Testing. Testing.
Where's Bill Bazare? He's not here, that chicken.
It's a conflict.
Conflict with what?
With Jenny.
Oh, yes.
In compliance with the Open Public Meetings Act of 1975, adequate notice of this meeting has been provided. If any member has reason to believe this meeting is being held in violation of this act, they should so state at this time. Everybody turn your phones on silent if you haven't already. Just make sure that's done. And we have our Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Karen, roll call, please.
Yes, Mr. Bazare? Mr. Jones?
Yes.
Mr. Riggs?
Here.
Mr. Crowley?
Here.
Mr. Gorgone?
Here.
Mayor Mullick?
Here.
Deputy Mayor McDade?
Here.
Mrs. Reed?
Here.
Mr. Lundholm?
Here.
Mr. Paducis?
Here.
Mr. Crippen?
Here.
Thank you.
All right, we have two resolutions we have to approve. First resolution is 06-10-2025, Mahalo Cape May LLC, 1033 Beach Avenue, Block 1101, Lot Number 1. Is there a motion?
I'll make the motion. I second.
Deputy Mayor McDade motions. Mrs. Reed seconds. Mr. Gorgone?
Yes.
Mayor Mullick?
Abstain due to my absence.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Abstain.
Mr. Lundholm?
Abstain.
Mr. Riggs?
I believe I was absent. Abstain.
Thank you. Mr. Paducis?
Yes.
Mr. Jones?
Yes.
Thank you.
Second resolution is 06-10-2025, Arlene Luciani, 1361A Illinois Avenue, Block 1154, Lot Number 38. Is there a motion?
I'll make the motion.
So moved.
So Deputy Mayor McDade motions. Mr. Gorgone seconds. Mr. Gorgone?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Abstain.
Mr. Riggs?
Abstain due to my absence.
Mr. Paducis?
Yes.
Mr. Jones?
Yes.
Thank you.
We're going to get through these other things very quickly, and so we can just have this application for this evening. Next, we're going to have payment of bills. Is there a motion?
I'll make a motion. Second.
Mr. Lundholm motions. Mr. Riggs seconds. Mr. Gorgone?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Paducis?
Yes.
Mr. Jones?
Yes.
Thank you.
And also, we have 3 draft ordinances we're just going to put out there. We will be discussing those this evening, but we're just going to make sure that they get out there this evening. I'm not going to go over each one of those, but they are, everybody has to take a look at them, please, on the board. I think we left off to begin with our city engineer to put his presentation. You guys want to come up here, or you want to, let's wait till he gets done? No. Okay, Craig, you're up now for your presentation, please.
Thank you. Oops, sorry. Be sure the mic's on. Okay, I would like to summarize my application review dated March 27, 2025 for the A-View LLC, A-View Resort. This project is located in the C3 Hotel Motel District. The applicant is seeking preliminary and final site plan approval with variances for to replace an existing motel with a proposed hotel with 50 one-bedroom units, 3 two-bedroom units, a 162-seat restaurant, a 37-seat bar, a 41-seat bar and pool, a 29-seat guest library, a 12-seat outdoor terrace, and other hotel amenities. Parking for 79 vehicles is also proposed via ground floor parking within the structure. The 79 parking spaces include a number of stacked parking spaces with vehicles that are inaccessible unless another car is moved. Valet parking services are proposed by the applicant. There is also a loading space that's proposed within the existing 25-foot access easement. So that's a summary of the improvements. With regards to the completeness review, that's located on page 3 of 11, there were some outstanding items. Some of these have been preliminarily discussed. I'll just highlight these since this is kind of refreshing everyone's memory from what occurred at the previous application. There was a waiver request from providing the justification to demonstrate the waivers, so we should rely on the applicant's testimony with regards to the waivers. Under the general requirements for all applications, that's item number 7. Item number 8 is any sections for which a waiver or bulk area variance is specifically requested, and a narrative explaining why the applicant is entitled to such a waiver. That stuff was not included in the original application. You've heard testimony from the applicants indicating the variances that they're requesting. That is from the number of parking spaces, from stacked parking configuration, and my report indicates site triangle variances. However, the testimony from the applicant's engineer is that they will comply with that, so there's no variance being requested from that item. Under the details required for preliminary site plan approval, under 1B, the variance must be indicated on the plan. That should be a condition of approval. 1K is providing the proposed buildings and structures and any existing structures to remain, et cetera. That's the building plans. As you recall, when we first started the application, I pointed out a discrepancy and asked the applicant to clarify which plan governed because they weren't consistent. We had the architectural plan is governing for the room layout and the overall building layouts. The seat plan was for the overall seat counts. So that was a discrepancy. I think we fleshed that out, and therefore I believe that item is at least partially been addressed. Item V, an EIS is required for all site plan applications unless specifically waived by the board. So in this case, I recommended that the New Jersey DEP CAFRA compliance statement be provided if the EIS is waived by the board. That has not been provided to us, so we do not have that in hand. So the applicant should testify and provide support in that, but ultimately, they will be required to get a CAFRA approval for this project, and that will be required of the state. So I thought it would be a good idea that the planning board get a copy of that also.
I'm sorry, I'm not sure I understand that one. Should we, sorry. Craig, I'm not sure I understand that one. I just want to get it right. Are we
The board has
giving them a waiver for the EIS?
The board has
or
to
no?
specifically waive that requirement. So if they feel that it's necessary, they can ask for it. Okay?
Okay, do you feel it's necessary?
So what occurred, this site has been the subject of numerous applications. When they came to us way back when, they provided us a copy of the CAFRA compliance statement at that time. They have not since done that for this application. Okay? So if the board feels that they need this for this, I mean, the site is developed, so, there's not a huge worry about environmental concerns that I'm aware of. So,
Does density,
what's that?
does density, I mean, the fact that it's, a smaller property now and would be expanded, is that an impact?
No, I think what
Environmental?
about like contamination stuff?
Okay, I just
Yeah,
wanted to clarify.
the only thing that could be, a phase one would be necessary to determine, contamination, et cetera.
Okay.
So, but I haven't heard any testimony with regards to that from the applicant, so, I'm going to pause after this completeness section and let them justify these variances, so you may hear what you need to hear from them.
When you say justified variances, you mean?
I mean waivers. These are checklist waivers. These are part of the required checklist that all applicants are required to submit. Okay? A traffic impact report is also required, and that has to be specifically waived by the board. They provided a parking assessment in lieu. It's my opinion that the streets that adjoin this property are adequate to handle the traffic from this type of use. All right, we're not going to get too far if you guys are yelling, so like, all right, so just relax. This project, I believe, lives or dies on the parking variance, the number of parking spaces. But the city streets that adjoin this do not need to be widened or improved to accommodate this development that is a permitted use in the zone. Okay, that's the standard. So it's my opinion that we can waive that, and I believe the parking assessment report, it should be the focus of your consideration with regards to parking and traffic. And then finally, letters AA is the requirement that they have to provide the site plan in digital format, and that should be a condition of any approval. So I would like to pause there, and I did recommend it conditionally complete. So if the board feels like they can grant those waivers, then we can grant completeness. Okay? So can we talk about the waivers?
Yes, absolutely. I mean,
I
I
think
can.
your engineer might want to.
No, sure.
Oh, no? He doesn't, he's shaking his head no.
No, yeah, sure. So, I mean, I think I can address one preliminarily as more of a matter of procedure, which is the CAFRA permit. So one of the conditions that is mentioned towards the end of your letter that I think ties well into the CAFRA aspect of this is that we are going to have to get any and all outside agency approvals in connection with this application. That includes DEP approval from specifically a CAFRA permit. We would readily agree to that condition. We actually do have a CAFRA permit, so right now it's really just a matter of extending that permit out. To the extent that the DEP will not extend it, then of course we have to get a new CAFRA permit relative to this new development. So that's without question. And given that this is a already largely developed site and the environmental impact is minimal at best, and we're actually adding green to it, we're decreasing the impervious coverage by about 4%, bringing that into compliance. The applicant is of the opinion that a waiver is warranted in this case. If there's any further questions that the board has relative to that, but I think that's relatively straightforward, at least from our perspective.
So the contamination was mentioned. Who, me? Make sure the mics are close.
And I'll use my old theater training and project a little more.
Okay. So I have a question.
Sure.
One, contamination was mentioned. Is there any known contamination at the site?
None.
I think should the applicant be answering? Rich?
Sure. Yep, come on up.
Yes, it's, the attorney's testimony, attorney statements are not testimony.
Okay.
Never mind. I think
okay.
Manny's coming up. I was just.
Yes,
That's why I'm looking at Richard.
there's been a series of phase one environmental assessments done. Nothing's been uncovered. Anytime we had to get financing, that was a requirement. The construction financing will probably ask us to either review the old phase ones or to get another one, and a more updated one. So, but we have never been made aware in the last 20 years of this project that there was any level of contamination on site.
And Manny, very quickly, just in relation to your statements, I just want to make sure the record is clear. You were sworn in at the last hearing. You were aware that you're still under oath for anything that you say before.
I'm aware.
Today, including what you just said.
Yes.
Okay, great. Thank you.
So is it enough to have a condition on DEP approval and/or an environmental impact study submitted, or what do you?
I believe so. The DEP environmental review is far more stringent than what a normal planning board would review. So I think we can grant that waiver if the board finds that testimony is acceptable.
Mr. King, are we able to ask for a copy of the environmental assessment that was done? Since we're waiving this, or is that not?
I'm not clear that my understanding, is there a DEP approval that addresses environmental concerns in existence? Does that document exist?
There's a DEP approval that addresses this site. There are no environmental concerns that exist per that approval.
Okay. So, but that's a document that can be made available to the board.
Yes, and to the extent it has to be extended or whatever the procedure is, that's where we'd readily agree to that as a condition of approval.
Okay.
Well, what is the date of that DEP document?
It was some time ago, so again, I do believe they typically last about 5 years. But I do believe we have to extend it. And again, to the extent that the DEP will not.
So what I have inventoried as what you've submitted is a CAFR individual permit from the New Jersey DEP dated 11/8/2018.
Yeah, so
The
we
last
need
5
that,
years,
yeah.
5 years, it would expire in 2023, so you would need to extend that.
Or get a new one, in which case we would do either.
Okay.
Everybody is using their mics. Listen, we will try to do that, but everybody's mic is on. It looks to me like they're speaking into their mics. We'll try, okay?
Okay. So that was the environmental impact
Should
statement.
everyone vote on that? I mean, that's.
Yeah, you probably should.
All right, can someone consider making a motion to grant a waiver, but acknowledging that there is a condition of approval that they obtain either an extension of their existing DEP permit or a new DEP permit for that waiver to be effective?
I'll make that motion.
Second.
I'm sorry, who seconded? Mr. Lundholm? Thank you. Deputy Mayor McDade motions, Mr. Lundholm seconds. Mr. Gorgone?
Yes.
Mayor Malik?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Produces?
Yes.
Mr. Jones?
Yes.
Thank you.
I believe you should also vote on the waiver of the traffic impact report and for them providing the parking assessment report in lieu of. If you need to hear from their traffic engineer in support of that, the board is certainly able to ask for that.
But just to clarify what I understood you to say, Craig, that a vote in favor of this waiver is not a vote saying that the parking is okay, but rather that the streets that are there are able to handle the permitted use of a hotel without expansion or reconfiguration. That's-
Correct. If you read that paragraph and what's required, it has nothing to do with parking. It has everything to do with the street geometrics and improvements that are along that street that would facilitate that development. It's typically asked for when a project requires widening, channelization of lanes, traffic signal improvements, stuff like that, which really are not being considered in this application. So I believe the traffic impact, or the traffic, let me make sure I say it right, parking assessment report is more appropriate for justification of the relief that's required as opposed to this traffic assessment, traffic impact report.
Does someone want to make that motion? It's a motion to grant a waiver of traffic impact study with the understanding this does not go to parking, but instead is an indication that the roads are able to handle the proposed use without reconfiguration or expansion. That's the motion I recommend being made. How you vote is up to you.
Motion, anybody want to, motion?
I'll make the motion.
I'll second.
Deputy Mayor McDade motions, Mr. Gorgone seconds. Mr. Gorgone?
Yes.
Mayor Malik?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
No, I'd like to hear some more information on that, so I'm going to vote no at this time.
Mr. Produces?
Yes.
Mr. Jones?
Yes.
Thank you.
Okay, so based on those recommendations, I did recommend deeming this application conditionally complete. You've granted a couple of the waivers that must be granted by the board. So the rest of the waivers, we can, unless we want to do an overall completeness vote right now, is probably more appropriate. Okay, so let's do that. So everything else should be conditions of approval as indicated or discussed. I am on the bottom of page, or the middle of page 4 at the end of the completeness.
All right, Craig, just because everybody's very focused on this tonight, I'm going to go over this a little more carefully. Can you
Yeah.
go to your page 3?
Sure.
Number 7, I have deleted. Make sure these are good. Number 6, because you know what this kind of gets reproduced. Yes, it's very difficult. Okay, you know that this goes into the resolution, so I just want to make sure that we take out the right stuff. So 7 is coming out, 8 is coming out. 1B, variances must be provided on the plan, that's a condition of approval. K, I've taken out because you said that they produced those plans and described them at the last hearing.
That's correct.
V was granted a waiver, which is the environmental. W was granted a waiver, which was the traffic, but not parking. And AA, I put as a condition of approval, which is the CD-ROM requirement. And with those decisions by the board, then it's a vote to deem the application complete. I'd recommend, given your prior votes, that you do deem it complete. So, but we should have a vote for that. So if someone can make that motion, and then we can move on to the rest of the report.
Is there a motion? I'll make a motion.
I'll second.
Mr. Jones motions, Deputy Mayor McDade seconds. Mr. Gorgon?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Riggs?
Yes.
Mr. Badousis?
Yes.
Mr. Jones?
Yes.
Thank you.
Just for the public's benefit, all the board did was say that there's sufficient information to review this and vote on this application tonight. Okay? All right. With regards to zoning requirements, at the bottom of page 4 of 11, I raised an issue because of the inconsistent plans that were submitted. There is a maximum accessory use area that cannot exceed 25% of the total floor area with regards to uses in the C3 hotel motel district. So hotels are a permitted use in the C3 zone, and the accessory uses that they're planning, whether it's a bar, a restaurant, pool areas, shops, et cetera, it counts as accessory area. So that area cannot total more than 25% of the total floor area. So the architectural plans have a breakdown of that and show that the total amenity space is 14,043 square foot of the 56,174 square feet, and that comes out to 25%. So they're not exceeding that based on the analysis that's provided on their architectural plans.
Craig, I have a question there.
Sure.
Your list of accessory uses, hotel, retail, restaurant, fitness, rooftop bar, restaurant, pantry, restroom, pantry, where's the library?
Where's the library?
Yeah,
The analysis?
is that not an accessory use also?
All right, this is probably a more appropriate question for Mr. Fenwick. Mr. Fenwick's plan showed a color-coded breakdown of all the uses. Do you have that plan with you?
Is this going to be something new from last time we had this discussion?
No, this is what he presented to us
Last time.
the last time.
Well, so we really don't need to see it again.
Unless, but you're asking a question about it that the architect is.
No, my question is, why isn't the library included as an accessory use under the 25% rule, and why shouldn't it
Mr.
be?
Fenwick, was it included in the 25%?
Well, let's have him come up, because one for the mic and two for just the sake of the record.
Mr. Crowley, it is in the footnote, just so you know. It says, for example, a 29-seat guest library is proposed.
I'm on
He's on a
page,
different page.
I'm on page 4.
Chart.
Yeah, I got that. It's not in.
Okay. I do see what you're saying, Mr. Crowley. It's not on that page.
Yeah, the bottom of those.
Yeah.
Are you satisfied?
No, no, he's not.
Okay.
Craig's right. We just got to see that chart.
architect's calculations are much more accurate than what I can do by just taking a scale to it. So that's why I asked them.
Mr. Chairman, Mr. Vice Chair, are they going to present, or are we in recess, or?
They're trying to find the answer to the question.
Okay, I'm just trying to figure out what they're doing.
They're trying to find the answer to the question.
Okay.
So Steve, I'll just remind you, and Rich, if you want to swear him in, that's fine. Just, you were
Remind
sworn
you you're
in.
under oath from the last hearing.
There you go.
Thank you. I understand I'm under oath. I believe the question was, is the library part of the amenity space? I believe the question was, is the library part of the amenity space or not? And it is part of the amenity space.
My question was, when we did the calculations for the 25% at the bottom of page 4, every space had its square footage listed. There was no square footage for a library, and you're saying it's part of the amenity package, it's under the 25%. Where is it?
Well, if we look at the color-coded plan for the amenity space on the level of the library, and the library is actually delineated on the seating plan, it is part of that space.
And what is the square footage of the library?
I would have to calculate it.
Come on.
I thought we just spent
These are
time looking
your
for that.
plans we're talking about, not my plans. They're
Yeah,
your
hold-
plans.
Hold on, everyone, before we
That's
devolve
right.
into an argument, we just spent 5 minutes looking at plans over there. Just break them out and show them that it's in the color coding.
Okay?
I thought that's what we were doing. Picture will save 1,000 words.
It's shaded. Just where's the area?
Yeah, I can see it.
Hold up, Steve, just.
Yeah, I see it.
Hold on.
This purple color is the amenity space. I can tell you the area of that space, but I do not have the library broken out from it, but it's included. This is the library space.
And what's the square footage of the purple section?
The square footage on the plan is 9,257 square feet.
So it was included in the line item for the restaurant/bar.
Okay, thank you, Craig.
It's rolled into the 9,202 for the bar.
Yes,
That's-
yes, it's all rolled together. It's not delineated, and there's a note saying that, it's schematic, and we reserve the right to adjust it within the square footage.
He listed here as part of 9202. Okay. Yeah, all right.
I'd like to make a request that anybody from the audience, please don't come up and talk to a person on this board. That's a no-no.
Someone did that?
Yeah.
Yeah,
Who specifically?
yeah, I didn't see it, but I would have said, don't do that.
What is this?
I don't know, but we're creating a record on our microphones, and that's the record, so people can't come up and talk to the board member. Whatever you were
Hold
told,
up,
disregard.
Yeah, I'd like to know which, just for the sake of it, I'd like to know which board member and what was exchanged, if possible.
Let me see it.
Dennis, who gave you
It
that?
says allocated of square footage for accessory parking space area, whatever that means, so take from that what you will.
Was that-
Just
and just-
disregard, if you can understand it, disregard it. Go ahead.
And that was presented to Mr. Crowley. I just want the record to be clear. That was presented to Mr. Crowley, I believe.
Yes, and I just read it to everyone.
No,
so
I
there's no
understood,
difference
understood,
if it's Mr.
understood.
Crowley or
I
not.
just want to be clear.
We good? Okay. All right. So I'm going to review the zoning table on page 5 of 11. With regards to the use, it is a proposed hotel with the accessory uses. That is a conforming use. The accessory use area, we just discussed, it may not exceed 25% of the total floor area. When this review was done, I had questions with regard to the plans that were not coinciding with the information on them with regards to the room layout and the areas We have clarified that, and that I that is in with regards to the status for accessory use area, I believe if we're using the architectural plans and we're relying on the architect's calculation of those amenity spaces, they are at 25%, and therefore it is a conforming accessory use area.
And one thing I can also say, sorry to interrupt you, Mr. Hurlis, is simply that to the extent required, the applicant would also agree to a condition that the amenity spaces be limited to 25%. They are, that's our official testimony, but to resolve any discrepancy to the extent that there is one, which of course I'm not conceding that there is given Mr. Fenwick's testimony, but we would concede to that as an additional condition of approval.
Okay. So continuing through that table, you'll look, the lot size is conforming in the zone. The building setback lines for both Beach Avenue and Second Avenue are proposed to be conforming. The lot width and lot frontage requirements are met. The lot is oversized based on that requirement. The units are required to have a minimum size. That has been shown on the architectural plans as conforming. The rear yard setbacks have been met at 20 feet. The side yard setback at 10 feet has been met. The building height requirement is 40 feet where sloped roofs are provided. They have sloped roofs. There's a cupola that is also permitted that exceeds that height. Our ordinance permits that exceeding of the height for that type of structure. Therefore, the building heights are conforming. And the lot coverage. It exists in a existing non-conforming situation at 78.84%. It's being reduced and brought into conformity at 74.98%, where 75% is the maximum permitted. Moving on to the next table at the bottom of the page, off-street parking standards. So the minimum parking size has been met. The minimum parking setbacks have been met. The minimum parking buffer requirements have been met. They have provided the requisite number of ADA spaces. They have provided the electric vehicle, EVSE MR spaces, which are included in the order. There are your electric vehicle space charging spaces. So they've provided the two that are required. Stacked parking is not permitted. So we've heard testimony from them indicating that that is not permitted. The board has supported stacked parking in certain cases where there is valet parking, but we typically have had valet parking protocols that have been submitted to the board in justification. You may want to hear more information from the applicant with regards to the valet parking and how that's going to work. Operational protocol, so that variance and justification of that is really predicated on the fact that that valet parking situation needs to operate in a good manner that's not going to impact any backups onto the side street of Second Avenue. It's not going to create any adverse parking situations. So, but when we have stacked parking spaces, we need staff in order to address that. So that should be a condition of approval, that operational protocols are provided.
Mr. Earlis, you agree that the testimony thus far is that there's actually 21 stacked parking spaces and not whatever number was originally in the application?
I believe that we counted those up at the last, and my notes don't reflect that, but I seem to, yeah, I'm sorry, there it is, 21 stacked. I have that on my notes.
My notes are there too, okay.
Okay.
So they're the same stuff, okay.
I do take good notes. All right, so the number of parking spaces. So there's a variance necessary for stacked parking. The number of parking spaces. So a hotel requires 1 space per sleeping room plus 1 space per employee on the largest shift. There's 56 sleeping rooms and 19 employees on the largest shift have been indicated. There is 240 restaurant bar seats that are indicated, and the requirement is to provide 1 space for each of the 4 seats. That is a total of 135 parking spaces that are required. The existing condition is 51 for the existing hotel. They're proposing, I believe, 79 parking spaces, with 21 of those being stacked parking spaces. That is a non-conforming situation. So there's a variance necessary.
Craig, I think it's 64 single spaces, so whatever 21 is on top of that.
64, 21?
Yeah.
64 and 21 stacked?
65 and 21 stacked. Yeah, 65. So I think that comes out to 86.
Great. Is it, I just crossed out 65. What are the numbers again?
It's 65 single spaces,
I just crossed.
plus the 21 proposed stack spaces, which comes out to 86 proposed parking spaces,
We
including,
have a total of 79 parking spaces shown on the plan.
I think that was the discrepancy last time, because I think the last time it was, appeared to be, I think it was 19 spaces, and then we corrected that based on what the plan actually showed. But Mr. Schaefer, if you want to come up real quick and address that? I remember this happening at the prior hearing, so I believe it was resolved, but
Let's
we're
get
happy
the
to go
record
through it.
right, then.
Yep, sure.
The total proposed number of parking spaces, including stacked parking spaces in the building, not on the street, is 79.
79.
79. Okay, that's what my report indicates. So the requirement is for on-site parking. So we don't count the off-street. I mean, that's,
We're not proposing to use off-street parking.
okay.
Of the 79, how many are stacked?
You're going to have to let me count them, because I don't think it's 21.
It's,
We counted last meeting, and you said it was 21.
That's what my notes say.
All right, well, just for a point of order, 65 plus 21 is not
79.
79, it's
It's
86, so I don't know what we're doing.
Okay, so 86 is the number,
You don't have 86 parking spaces. There's
Craig.
79.
Craig, you have 79 parking spaces on their plan? Is that the
Yes,
number?
I've counted them. There's
Right.
Let's say if you subtract, actually there are, I've counted the parking spaces too. There's 22 stacked parking spaces in this plan that,
Is that 11 and 11? 11 backed up to 11? Is that what?
I'll tell you, here it is, right here. There's some over there in that section by the trash receptacle. But my point, we'll go back to that in a minute, but my point is, if there's 79 parking spaces on the plan, and 21 or 22 of them are stacked parking spaces, how can there be 65 parking spaces left in the building after you accommodate the stacked parking?
Not, and that's
There's
why we're
not.
trying to clarify that.
And why are they saying it's 65?
I guess it's our second meeting in an application about a parking variance, and we don't know what the parking is.
And nothing is, we asked last time we went through this 3.5-hour discussion, we asked for some new information. We've got no new information. It's the same set of stuff we saw. This is the same map I was talking about last time. There's 22, wait, quiet. There's 22 stacked parking spaces identified on this map. There cannot be 65 parking spaces that are not stacked and still have 79. It's mathematically impossible. There's something still wrong with this set of plans.
We're asking them to provide clarification. They counted for us last time. Apparently, that count may be erroneous.
Yep,
Let's
it
let
may
them
be,
fix that.
yeah.
and what about the EVO?
These are, see, last time we had this discussion, they didn't even realize that there was a wall there. They thought parking spaces would go outside of the building underneath some.
Dennis,
sort of
let's
a
let them,
garage.
let's let them figure it out.
Okay, well,
So for the
This is a
folks who are
month
standing,
later.
I'm sorry, for the folks who are standing, there's some seats over here, rather than standing up against the wall, just to give you some, level of comfort.
All right, so the traffic consultant and I just recounted again, and there are 22 spaces stacked. You're right,
At 22 stacked.
right.
22 stacked spaces.
11 and 11. So there's 11 in the
Well,
front.
they're interspersed throughout. It's not just the two rows of 11. There's others at the end of the aisles that are also two cars each
Okay.
that are stacked. So
All right.
it totals 22.
And 65 regular.
no.
No, can't be. The math doesn't work.
Okay, it's your math, so I'm just trying to figure it out.
So that makes 57 non-stacked.
And by the way, if you're using the numbers to identify parking spaces, those 57 parking spaces are going to be for the people who are in the rooms. That's how many parking spaces you need for the rooms. There are no parking spaces inside this building for the staff, which you have to have by law. And so are they going to be valet parked? Or how is that going to get accommodated?
Everyone will be valet parked, employees and guests.
And so in your plan, I'm going off a little bit, I want to follow this issue if you let me. In your plan, which was submitted by the Marshall Group as a part of your, they talked about valet parking, and that valet attendants would be available when the guests check in and the guests check out. So what happens at 2 o'clock in the afternoon when a guest wants to have his car to take a ride to Wildwood?
I mean, yeah, I can answer that. I mean, this is, I can most certainly answer that. We'll have a member of our staff available to provide service to the parking and the valet parking area 24 hours a day.
So now you're adding staff.
No, I'm not adding staff. I'm not adding staff. There's duplication of duties where if you take what we have at the end of Cape May, on any given summer night at 2 o'clock in the morning, there's two bodies, there's two people, there's two employees working.
Well, it says
Okay,
in
there's
your-
a duplication of staff and duties. There's a duplication of staff and duties, okay? It doesn't add another employee. We don't, and you're asking for what happens in an unusual time when, and you're asking a very good question. What happens in an unusual time when I want my car? And the answer is, there's always a member of the staff that can handle those incidences and service the property. It's a small property. It doesn't have, it's a small property. It's not the sprawling venue where you need extra staff to get the job accomplished. But I'll answer whatever operational questions you have.
In the Marshall analysis of the plan, by the way, you identify front desk will be manned 24/7. How many people you give me no number there. How many people are on the front desk at that time?
One. And during check-in time, I mean, I can go through our whole operational plan for you, but I don't think that it'll help much, but I certainly will do that. During check-in hours and check-out hours, we'll have up to 2 members at the front desk, and that doesn't. But you can't. Don't take that to the bank, because we have an executive team that would jump in and help. And help out. Most of the time, there's going to be one person at the front desk.
The executive team you talk about, is that administrative and management?
Yes.
Yeah, you say there's a general manager, but there's a team there. How many in the team?
I didn't say.
Let's see.
I said an executive team, and when I mean an executive team, we have more than one hotel in Cape May. We're going to have a GM. We're going to have called an innkeeper, a GM, that's going to wear multiple hats. And that's one of the great news. That's the economy of scale of having multiple properties, and being able to do that allows you to have multiple uses for the same employee.
And here's the problem. You got a lot of parking spaces unprovided, and some of them are coming based on the assessment of how many staff you have. If you can't tell us how many staff are going to be here, we can't know how many parking spaces you need.
Mr. Crowley, if I may, at the last hearing and on the applicant's plans, we've testified that the max number of employees at max shift is 19. So that calculation is based on that number.
That's correct.
19.
Can
19.
I ask an operational question since we were on there? You said that you have multiple hotels in Cape May.
Correct.
Is there going to be an opportunity for guests to be shuttled from one hotel to the other? Do they have that access to both if you're in at the?
We haven't contemplated that. The problem with that is that the experience at the Cove is going to be an all-inclusive experience. So it doesn't allow for this cross use, the cross use of additional guests. Number one. Number two, if I'm paying my good money to stay at the jetty, I don't want anybody else there.
I'd like to get back to let Craig finish his report. Craig?
I just have one other question on the parking.
Sure.
I'm seeing 2 electric vehicle parking spaces, and then you designated one of them also as handicapped. Is that correct? Am I seeing that right?
Yes.
Well, there's two.
How could it be for electric vehicles and a handicap space?
In terms of an electric vehicle, what,
I'm not sure I answered.
Andy, you can probably, yep.
I don't know. Sure.
It's required that one
Besides an engineer or planner, I'm an ADA expert in terms of outdoor, not inside a building, I never want to know. But in terms of parking, the ADA rules are fairly gray. It sounds like they're suggesting that you should have at least one ADA parking space that's EV and at least one that's not. It's not a hard and fast rule, but it looks like that was the intention of it. And so that's the practice we've been doing for site plan with parking, is if there's two required, one's an ADA space and one is a normal space.
Thank you.
Thank you.
On the employees thing, the parking is calculated based on 19 people at the maximum shift. So what you're really deciding is whether you find it credible that 19 people can handle this hotel. The ins and outs of how many people are there at any given hour or time of day is not a valid consideration, in my opinion, because you've held them to the maximum number. So if they were saying, well, we only need 2 most of the time, and then we need 14 another time, so we only need 7 parking spaces, well, then that matters. But you're holding them to the highest number they can need at any time, and that number is 19. So you have to decide whether the weight of the testimony indicates to you that there's 19 is enough, or if there's more than 19 people needed at the hotel at a given time, and everything else is mostly noise.
Craig, are you capable of finishing up now your box for the proposed parking?
Yes, so now Mr. King uses my memorandum as the basis for his resolution for approvals and denials. So, Mr. King, I believe now that we've clarified that what is in that last number of parking spaces should be 57 single spaces with up to 79 double stacked valet parking.
What I wrote in that box is 57 single spaces and 22 stacked for a total of 79.
That's even more clarified.
That's what I have in the
Okay.
box right
All
now.
right, perfect. That's what we're running with. Okay, so you're being asked to grant a variance from the 79 total parking spaces, including the stacked spaces, where 135 spaces are required. Now, I put in a little asterisk next to that 135 spaces. Below that is a little paragraph, and I just wanted to bring that to your attention. I had some concerns with that parking calculation. For accessory uses, the applicant has indicated the proposed on-site amenities, including the pool, restaurant, and bars, are restricted to hotel guests only. Additional areas could be considered contributory to the required parking calculation. And I give an example. For example, a 29-seat guest library is proposed immediately next to the restaurant and bar. I mean, it is essentially touching the bar rail, that amenity space. So I had concerns like this area could drive up the parking. So it was a concern of mine. It should be, the board should consider it. But this parking variance is predicated on the all-inclusive operation plan protocols. So in order for the board to feel comfortable in granting this variance, I believe they have to find validity in the fact that this hotel is going to operate and exclude the public. If the public is brought into this restaurant, I can promise you there will be widespread parking problems in that neighborhood. Okay, so takes care of the parking variance. The signage review is on page 6 of 11, and I won't bore you with that, but you'll notice that the proposed signage all conforms to the requirements of the code, and therefore it's conforming and there's no variances required. The list of variances that I have on page 6 of 11, we should strike number 3. The applicant's testimony indicated that they will comply with the safety regulations. The signage and landscaping will be moved out of the site triangle and will comply with the code. So there are 2 variances that should remain: the number of parking spaces and for the stacked parking spaces.
Craig,
Yes.
just a technical question. Why, at that section of the report you gave, why did you say the applicant has not requested any variances?
There was no variances requested on the application form and none indicated on the plan. But their notice indicates that they're requesting the variances. Their testimony has indicated that they're requesting those 2 variances. I think that issue has been clarified.
Okay.
But at the time of review, I didn't have that, and they didn't request any variances. Okay? All right. Is there any more questions with regard to the variances that have been requested? Okay?
Craig, I just have a question.
Sure.
In this document, it says there's 3,631 feet of pool deck on the second or third floor. That not included in that 25%?
When you see this document, you see which documents are more.
This is
It's
the,
the Mar-
It's in my,
Marshall-
it's the app,
On the application.
and the application on page,
they didn't do pages.
Yeah, the
It was
page
just
number.
attachment. It was the Marshall Company.
but the plan of action,
Plan of action.
and it,
Dated
and it,
October 2020.
and it says there's 3,631 square feet of pool deck space.
the application?
But that's not included in this 25% of the,
Rich, can you?
amenity space.
What page is that on?
It's in this. it's
Yeah,
part
can I
of the
use your-
attachment. It's called the A-View Hotel Plan of Action dated October 2024. It was in the applicant's paper dump.
Oh, here it is.
here it is. I don't know.
You're talking about letter C on the plan of action?
Yes.
Okay. I'll read it into the record. The new hotel will have a 3,631 square foot pool deck and with an adjacent 523 square foot rooftop lounge, open Labor Day through Memorial Day, but also open weekends in the fall. There will be no lifeguards as the pool will not have a deep end or diving board, and there will be signs placed in strategic positions around the pool indicating that guests swim at their own risk. The question to me was whether that was included in the amenity space.
Is the pool deck considered accessory space? That's my question.
It does not look like it was counted. It is shaded, it's shaded tan, but this is a question that should be followed up with the architect since he prepared this plan, but I don't think it's included. Go, please use a microphone.
The pool is not included as part of the accessory area.
Okay, yeah, I saw it on there, and it wasn't listed, I'm just asking.
No, it's not included.
The question
I
is,
should
should it be?
clarify that maybe it creates a bit of a confusion because it's within the footprint of the building, whereas typically you would have a pool in the configuration of the current motel, which would be outside on the lawn, and you wouldn't count it as an accessory
I'm
either.
not questioning the
Right.
pool, I'm questioning the pool area,
No, the pool area in general is not included.
okay?
It's a beige tone on the plan that was submitted, not a purple tone.
What exactly will be out there? Chairs, lounge chairs?
Yeah, just the same as if you were, you know, at a
that
pool
considered-
on the ground.
Well, that would be considered a patio area then, right?
I guess so, yeah, patio
Okay, so
area.
aren't patio areas considered part of an accessory use?
No, I don't believe so, not if they're outside the building.
All right.
Is it outdoor area?
It's an outdoor area, it's open to
Not
the
heated,
sky.
It's not enclosed?
It's not heated, it's not enclosed, it's not really part of the
So
building.
we've had this question on other applications, and the ordinance does not really guide us into how do we, but I know that we've discussed this on other applications with regards to pool decks and patios and amenities like that, but there is no hard, fast rule in the code. It's more up to interpretation as to whether it's amenity area. Now, that being said, the threshold is, where is it? The proposed accessory use area may not exceed 25% of the total floor area. So it's based on the total floor area. It doesn't say accessory use area is not qualified as indoors, outdoors, et cetera. So I'm at a loss to tell you and direct you how to interpret that.
Well, typically in my world, floor area is enclosed space. That is how we would calculate square footage.
Well, the bottom number in the fraction is total floor area.
Right.
The top number is the proposed accessory use area.
Yes.
And what does that mean?
Well, let me ask you this. Let's take that square footage of this pool area
Right.
and lay it onto the 25%. What would that number be then?
They're right at the 25% with that number excluded. They would-
Right.
That would
It'd be over.
Oh, you'd be over.
Oh, yeah, definitely.
Well, okay.
So the question is, should it be included or not?
Well, I think the
Why
ultimate.
would it be included? Unless you wanted to include it
Well, the only reason why I
to
asked is
create a
because
problem.
it's not on the ground level away from the building. It's actually on like the second floor, right?
It's on the roof,
Right, so
Yeah,
it's part of the
okay.
building. It's not like it's outside the backyard.
but
Well,
it's not
think-
enclosed.
I think the question becomes whether or not, and Craig, correct me if you think I'm wrong, whether or not floor area is limited to enclosed space or it isn't. So for example, Steve, the bottom number of that fraction as included on our calculations, that's strictly enclosed space, correct?
Correct.
And then 25% of that, which excludes the pool, which is not enclosed, constitutes the amenity space in question. Am I correct in that? Okay. So the bottom number of that fraction doesn't include the roof area.
Correct.
Okay.
I did not think that we had an issue about this because you were complying with it, and now we got to start from the beginning because, call me intuitive. I think there might be an appeal of this thing, so I want to focus on it and get it right. So can we go to the section that talks about accessory uses being 25%? Because I'm a little unclear on that myself. Is the lobby an accessory use? I always envisioned it like the Peter Shields is the one that always comes to my mind. Everybody thinks it's a restaurant, it's really a hotel. And the restaurant can't be more than 25% of the building. So to me, a restaurant is a use and a hotel is a use. I don't know if a library is a use. Like I'm having trouble figuring out if the lobby of Congress Hall is an accessory use. I know the stores are, but I don't know if the library, if the lobby is, or the historical section you walk through down at the end. I'm not clear on that. So if this is going to be an issue, I want to go back to the ordinance and let's read what it says and
Here we go.
do it right. What section is the 25%?
So I can define accessory use, that I do have in front of me. This
Tell
is
us where
section-
you're reading from, please. Do you mind what section you're in?
Yeah, I was going to say that, thank you. It's section 525-4. Accessory use or building is defined, quote, a subordinate use or building customarily incident to, that might mean to say incidental to, and located on the same lot with a main use or building. So it refers typically to a subordinate use or building customarily incidental to the primary use. So I don't know that a lobby in and of itself constitutes a use as opposed to simply a necessary part of a hotel. A separate use would constitute something as a restaurant, meaning something that, I think a good delineation of that, and the board can correct me if they think I'm wrong, if it has a separate parking qualification or separate parking requirement related to it, then maybe that's an appropriate barometer. But Mr. Steve Fenwick's testimony is it relates to enclosure as opposed to the other item.
Why is the rooftop bar included then? That's your argument, is it,
Because I think it's related to parking.
but you're an all-inclusive resort, right?
That's true.
Okay, yeah, it is true. That's what you said.
Mr. King asked a question that I would like to answer. So the C3 Hotel Motel District has standards for accessory uses. Under section 525-24A2, accessory uses. Subsection G is the section that I was referring to. And that says, uses which are clearly incidental and accessory to the uses by right and conditional uses, comma, including dining or other service facilities, conference and meeting facilities, and exhibit space in conjunction with hotels and motels, provided such uses may not occupy the equivalent of more than 25% of the total floor area of the principal use. That's the standard.
There you go.
Okay.
So it's in the building, and it's used by the guests.
It's not in the building, it's on top of the building.
Put the rooftop on.
Is that 3,600
If it was
square?
on the ground, you wouldn't even think of it that way. Because it's on the building, now you're perceiving it as part of the floor area, but it's not part of the floor area, it's open to the sky.
So then, is that 3,600 square feet counted in that 56,000? Because if it's not floor area, then it shouldn't be.
That's right. I don't know, I don't, I'd have to check.
That's kind of
Was the
important.
floor area, was that area of the pool part of the calculation of the
Yeah,
total
I-
area of the building?
No, I asked if it was in that,
If it wasn't, and
That
you
was
were
the
to add
question
that in.
just asked, yeah.
And then you were to include
double
that
dipping.
same square footage as an accessory use, it comes to 1, because you'd have the same number over the same number. So it would be 1, so you'd still have 25%, if that area was not part of the calculation for the floor area.
So Mr. Fenwick is checking on that. So, and I do want to just address, I think, more of a procedural item with the board. If the applicant seems a little disorganized at this time, one, I'll apologize for that, but the reason for that is simply because when we concluded at the last hearing, after presenting 3.5 hours worth of testimony, we advised the board that we had concluded our case in chief. So I'm not in any way trying to scold the board in any type of fashion for asking more questions. It's just that the applicant was under the impression that the case in chief, that we had addressed the board's questions and that our case in chief was complete. So if we seem a little like we're trying to come up with answers to questions we weren't necessarily prepared to answer, that's the reason why. So I just wanted to clarify that for the board and the public's edification, that we were under the impression that, again, our case in chief, with the exception of rebuttal, was completed. So that's why my witnesses are not necessarily prepared to address some questions that they weren't necessarily anticipating. So I do want to make that very clear as a procedural note.
So,
But on the other hand, the board does,
No, it's what I'm saying.
Board wants to get the facts
You
straight.
want to get the facts right. No, I just, because the public, I can hear, I'm not deaf, I can hear the chuckles, I can hear the gasps.
so
That's the reason why.
So I can just clarify your position then. The pool is not an accessory, in your opinion.
No,
Well-
it's not that it's not accessory. I think what Mr. Fenwick is arguing and presenting to the board is that floor area ratio, which is how that 25% number is calculated, is based upon enclosed space. The
Okay, then
roof in and of itself.
explain why, if that's the case, and his interpretation is the pool's not part of that floor area ratio calculation, why is the bar and the seating area right next to the pool on the roof also a part of the accessory use? Why is that same space used for something which is not an accessory right next to something which is an accessory?
That's a very good question. The floor area for the top floor is approximately 3,600 square feet less than the floor below. So it does not include the pool patio and the pool. Not included.
But the bar and the seating
So
area...
it's not included in the
Yeah,
total
okay, you're,
building area.
All right, I'm going to, this is a bit of a legal question, I guess, so I'm going to give you my opinion, which is not nearly as thoughtful or reliable as I would like, because I'm dealing with this now.
We are both on.
Here's my best analysis. The C3 Motel Hotel District has a list of uses by right, and then has a list of accessory uses. Those accessory uses include residential apartments, drinking establishments, off-street parking facilities, private, semi-private recreation facilities, residential accessory uses subject to 525-55, which, by the way, a pool is an accessory use at a residence. They use the word use, not structure. So that weighs in favor of a pool being an accessory use. F is storage of goods, and G, which is the one that's most relevant, says, and this is in relation to hotels specifically, uses which are incidental and accessory to the uses by right and conditional uses, including dining or other service facilities, conference and meeting facilities, and exhibit space in conjunction with hotels and motels, provided such uses may not occupy the equivalent of more than 25% of the total floor area of the principal use. So to me, the question is whether a pool in the context of a hotel is an accessory use, just as a pool is an accessory use in a residence. It should be considered the same. And I don't think so. I think the ordinance is not intended to capture things that, like pools that are used at hotels being more than 25%. I don't think it's a major big deal if they want to have a big pool at a hotel. I think the idea is trying to get other uses in the hotel, like service facilities, conference rooms, and meeting facilities and exhibit space that generate more traffic
Parking, that's-
for the hotel and thereby create more parking.
Drinking.
That is why Craig is very focused and appropriately focused on the bar and things that are near the bar that seem to be able to be used
why we include
for the bar, such as a library. If this library were sitting on the third floor quietly overlooking the ocean, that might be one thing, but it's a bar that's an open space. It's a library that's an open space next to a bar. So that's appropriately, in my opinion, or incorporated into these dining facilities as accessory use. To me, a lobby is not what this section G is driving towards. It raises the question about the Peter Shields Inn. I recall that they had a patio, and that was being used for restaurant seating. So we consider that an expansion of the 25% of the restaurant use. If it were an empty patio where people just sat and chatted who are hotel guests, I'm not so sure that that would have been an expansion of the 25%, because a sitting area is not really an accessory use, even though it's an amenity of a hotel. I don't think paragraph G was driving towards that. So in my opinion, this big open area around the pool, I don't think that that should be something that should shrink the size of a hotel because it's a 25%, counts in the 25%. That doesn't make sense to me personally. So I don't think they should include this big open outside area around a pool as something that would be considered part of conference areas, meeting facilities, and exhibit space, or dining areas and things like that. It's not the same. So that's just my opinion. I don't vote, but that's my analysis in the 6 minutes I got to think about it. All right, so let's go on to the next thing.
All right. So that was, I asked if the board had any questions with regard to variances. I think we're done there? Okay. So with regard to design waiver, I'm on page 8 of 11. In the middle of the page, there were no design waivers requested, so they've met those standards, and I didn't find any that needed to be addressed. With regards to the general review comments, these should all be conditions of approval. So under number 1, we've asked them to revise the zoning table to reflect the comments in this review memorandum. We've also, as a condition of approval, I talked about the inconsistency between the seating plans and the architectural plans. That should be remedied as a condition of approval. All the variances requested should be indicated on the plan, and then I've asked for the approval signature lines to be added to the plan. Item number 2 is more informational, and I sort of talked about that, but that is the review of the building height standard. They are allowed to exceed 35 feet if certain thresholds are met. They've provided the slope roof, which gets them an extra 5 feet, so they're allowed to have 40-foot maximum height, and the cupola, which is 10 feet higher, is permitted to exceed the height in accordance with the code. Item number 3 is our standard condition. They have to conform with Chapter 258, which is the Flood Damage Protection Code, since they are building in a flood area. Item number 4 and item number 10 are related, and that's all, I'm starting on the beginning of page 9 of 11. I think we talked about, at the last meeting, we talked about the 25-foot wide access easement, and there was some dialogue with regards to that. I believe it's a legal issue. and I will defer to the board attorney, but it's pointing out the fact that they are proposing a 12 by 55 loading space was proposed in that driveway easement, and I wanted to make sure that it is appropriate and legal to do so.
I don't think that's our decision.
That's why I'm
we dealt with
deferring
it-
to you.
Yeah, we dealt with this last time, and I think I said it last time. I may be wrong, but at least I'm consistent, that we're requiring a loading zone. They're required to have it there. If there's some private restriction that prevents them from having it there, then they have a problem because they can't do what we told them to do. So that's something they have to deal with their neighbor directly or with the court, but we're not going to decide that. We require the loading zone. It's appropriately placed there in terms of, from an engineering perspective, whether their property rights permit it, they have to deal with that on their own. And that's what my notes say from the last meeting because I read them before we got here.
And that's why I deferred it to you.
Thank you, sir.
All right. So that takes care of items 4 and 10. Item number 5 is dealing with the pool that's located on the 3rd floor. There was not a lighting plan provided for that. So I recommended that the design should be dark sky compliant in accordance with the code and not have impacts on adjoining properties. So as a condition of any approval, they should provide the lighting plan for the board engineer's review and approval. Item number 6, I asked them to verify the proposed on-site amenities, including the pool, restaurant, and bars are restricted to hotel guest use only, as indicated on the site plan. The applicant should detail how this restriction will be enforced. I think they've done that through testimony. If the board is requesting additional information to be provided on the plans or in the resolution as condition of approval, they should do so when they vote or prior to them voting. Item number 7, the building design and signage must be approved by the Historic Preservation Commission. So that's advice to the applicants. I have not seen any conceptual or final historic preservation approvals for this application.
Craig, if I may, we did receive those. However, there was some concern over whether or not they had expired. We have since refiled. We're on the HPC's agenda for next Monday, June 16th, relating to both conceptual approval and demolition of the existing structure.
Okay, so that statement is still true. That stuff must be approved by the Historic Preservation Commission. Item number 8 is the review of the vegetation and landscaping plan. We found it acceptable, so there was no issues with that. The plans indicate the make-ready electric vehicle spaces. Those spaces must be provided in accordance with the code requirements. So there's additional information that needs to be provided on the plans just to verify that, but they have set aside that the required spaces for that, the requirement of the code. There are some notes that need to be added to the plan. 10 was addressed by comment number 4 and Rich's comments. Item number 11 is, that was an informational comment, and it just indicates the number of employees for the largest shift was indicated at 19, and the staffing plan was indicated within the submitted action plan. Item number 12, I've asked for some additional information to be added on the plans to verify the one-way circulation can be provided with the parking areas. So we've asked the applicant engineer to certify and verify traffic control measures are adequate to provide safe and efficient traffic circulation. And I'm most worried about essentially the cut-through as you travel into the site or underneath the building, as you turn back out towards 2nd Avenue, that negotiation and traffic movement is a little difficult. I've asked for the traffic movements to be shown on the plan, and turning movements for the appropriate vehicles. So that should be a condition of approval. Item number 13, so this deals with the on-street improvements. So the applicant has proposed the elimination of one continuous driveway curb cut along 2nd Avenue with 2 proposed driveway curb cuts and elimination of both driveway curb cuts on Beach Avenue. So they've eliminated back-out parking. That's always a benefit. So there's opportunities for additional on-street parking, and approximately 5 spaces on 2nd Avenue may be appropriate. I'm not sure how that works out, but ultimately the city can decides as to what's appropriate and whether those are metered or not. There's no parking that's currently permitted on Beach Avenue. So, and based on the new improvements that were put there and the reconfiguration of the turnaround at the end of Beach Avenue, the city can reevaluate that and see if they can provide those spaces or not, but ultimately it will require city approval. I just wanted to point that out. So the applicant can't just decide to put 6 spaces on the street. They can petition the city and apply to the city to make that happen. If the city decides that's appropriate, then we get an additional 6 spaces on Beach Avenue, 5 or 6 spaces. 14 is our standard condition that they have to replace all sidewalks satisfactory to the board engineer, and we evaluate that prior to issuance of any COs. 15 is our evaluation of their solid waste and recycling report. They demonstrates adequate space for trash and recycling within the proposed hotel has been provided. They're utilizing wheeled containers to be loaded within the building receiving trash room loading area, which was indicated on the plans. The hours of unloading and loading, this is item number 16, have been indicated as during business hours. I believe that was clarified during testimony as 9 to 5, and that should be a condition of approval. Item number 17 is our review of the requirements for stormwater management. We did find the proposed stormwater management system comprised of a subsurface infiltration structure acceptable. They're also reducing the overall coverage on site. That's a good thing. 18, in addition to those proposed improvements for that management, stormwater management system, they have to provide a maintenance plan that's provided in accordance with the code. That should be a condition of approval. They also have to comply with Chapter 525, the minimum stormwater management and grading requirements, both during construction and after construction. That follows the project moving forward in case there's any problems subsequently after building that. Item number 20 is the requirement for them to get city approval for the proposed sewer and water connections. 21 is our standard condition that they have to furnish the required performance guarantees and inspection escrows that are required with any site plan approval. 22 follows along with that, in that they have to pay for the inspection escrows, and the certificate of occupancies are tied to the acceptance of improvements. 23 is our standard request that they comply with the recommendations and requirements of the Fire Department, Police Department, Public Works Department, Environmental Commission, and Shade Tree Commission. We did receive reports, and I will just highlight those. The Environmental Commission recommended approval, and they are commended for the use of seaside-tolerant native plants in the landscaping plan, and that is dated 3/12/25. The Fire Department recommended approval with the following conditions. They need the location of the fire suppression system and the proposed FDC location, elevator location, and also the control room, and they ask if there are any proposed standpipes for this building. Is the applicant willing to comply with all of those requirements? And I would actually recommend that a proposed standpipe be provided for that building.
Yes.
Okay, so those should be conditions of approval. That was dated 2/27/2025. The Police Department review recommended approval with no comments, dated 2/25/25. Public Works recommended approval with a memorandum dated 3/3/25. Shade Tree Commission recommended approval with a note indicating there are no trees on the property, and that was dated March 10th, 2025. So that was all of the review memos from those departments. Where am I? Okay. Page 11. Once again, I just hash out the fact that the project is located within a historic district, and that ultimately HPC approval is required. 25 is the notice that That portion of Beach Avenue is a city and not a county right-of-way, and there's been recent municipal street improvements that have been completed. The survey has been updated to include those new right-of-way improvements, but does not include the new turnaround. The applicant should be aware that that street is under moratorium for road openings, and improvements may be in effect, and that city approval is required for any disturbances within that right-of-way. 26 is our standard condition that they have to comply with all other necessary state, county, and local approvals, which include Cape Atlantic Soil Conservation District, Sewer and Water Department, the Cape May City Street Opening Permit, as well as the New Jersey DEP's CAFR approval. And we will require evidence of those approvals. 27, they have to comply with any and all applicable affordable housing requirements at the time of approval. And then 28 is just, I'll skip that. 29, should the board grant approval, the applicant is required to revise the plans to address the conditions that the board sets and submit those recommended number of compliance plans to the board engineer for review and approval. That is a summary of my report, and I'm happy to answer any questions the board has.
Does the board have any questions for Craig? Any questions? No. Okay, we're going to open this up to the public now. All those people that were noticed within 200 feet can speak first. The applicant will state their name and their address, and they will be sworn in by our solicitor.
Should I sit? Do they?
You can
hear?
stay there. That's
Okay,
fine.
all right.
Okay, it looks like we're going to do this a number of times, so please listen carefully. When you get to the podium, please say your name. No matter how easy you think it is, please spell it. Then say your address clearly and slowly, because I have to take it all down. So please follow those rules. It'll go faster. Then I'll swear you in. I'll mumble real quick a swearing in, then you say I do. Hold on. You got to... Can we yell at you to yell and talk to the microphone?
Yeah, because I was looking for the microphone. I got it.
Listen, I would like, before you start, we discussed it a little bit. We're going to have a 5-minute max for the public to speak.
I'd like a little longer. I feel that they spoke for 3.5 hours. I paid for an attorney to be here for up now almost 6 hours. I feel that representing 20...
How long do you expect to speak?
7 or 8 minutes. It's not going to be long. If I can get this to work.
Everyone else, 5 minutes.
Karen, it's not working.
Okay, you're going to say your name and spell it?
Name is Jay Klusterboer, Klosterboer.
Your address?
25 2nd Avenue.
As if I didn't say a word.
All right, let's try
Do
this.
you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do. I am. Let me get this right. Let's see. Cape May Meeting Hall, correct?
You're on the clock.
There we go. Connecting. It blocks out. No, I did, and then it blocks it out. It blocks it out. Blocks it out. Scott, you want to go first while we get the technology working? Let me see if we can get the technology working, because it's important.
Someone else is going to come up in the middle of technology, which...
Okay. All right. That's fine. We'll get our technology straightened away. And anyone else within 200 feet would like to speak?
We tested it yesterday.
Sorry?
Scott Maslow, 18 2nd Avenue, Maslow, MAS, LOW. I'll be centering on the most glaring problem with this
Maz,
application.
what was your address again, please?
What's that?
He wants your address again. What's your address again?
I have to write down the things you say. Just say your address again slowly, please.
And I
Okay,
think
I
it's
only
because
have 5 minutes, so it's going fast.
the fan is-
Scott Maslow at 18 Second Avenue.
Thank you, sir. Go ahead.
Sure. I'll be centering on the most glaring problems with this application, the parking variances. Parking variances is a cornerstone of controlling overdevelopment of any property, commercial or residential. That is why the applicants are required to prove their specific hardship or show a substantial benefit to the city, especially in the neighborhood it affects. This application fails miserably both criteria. This application will live or die just on the stacked parking variances. I had that before you, Greg. Let me first address stacked parking. Stacked parking was explicitly written in our code for a reason. It was placed there a long time ago to discourage the demolition of old historic hotels. It was never intended to be used for new construction. This novel legal maneuver by the applicant in his attempt to increase the density was his attempt to increase the density and usage of this hotel. At approximately the same period of time, another code was enacted to allow parking underneath hotels. It encouraged the demolition of old, non-historic hotels with the caveat of increasing the number of rooms. At this point of our history, Cape May needed the ratables. As such, the jetty may expand substantially just by following our codes. But again, never in our history has a hotel been granted both stacked parking variances and parking underneath to expand. You need to take into consideration for every stacked parking variance you allow, you are increasing the number of allowable units. This application is requesting now 22 stacked parking variances, which will increase the number of allowable units by 22. There is no public benefit, nor is there any part of our master plan that justifies such a dense project that requires this many variances. To give you some further scale and history of our town, the last hotel in Cape May to undergo a complete demolition and new construction was the Sandpiper Hotel. I'm familiar with the application because I was a friend of the owners. Their property was approximately twice the size of the current Jetty Motel. The number of units at the Sandpiper is 51, one more than the Jetty is requesting. They never applied for a 240-seat restaurant bar. They requested and got no stacked parking variances, nor did they request any on-street variances. In my opinion, the Sandpiper was built to scale and what we should expect of new designs being built in our city. This proposal does nothing to improve the Cove or Cape May. Now let me address my biggest concern, their request for 60 on-street variances. Like many of you, I live in an R2 zone. We are not in a commercial district. 95% of my surrounding neighborhood or blocks are in an R2 zone. Remember, this applicant is asking for 60 variances for on-street parking in an area that is already maxed out by the current demand for on-street parking. You all know this area of town and its importance as a beach drop-off point, among many other things. While I was thinking of the impact that this extra demand would have on the surrounding neighborhood, I did a little survey of our 2 blocks surrounding 2nd Avenue closest to the Jetty Motel. The changes in our neighborhood are not unique in Cape May. So your decision for this application potentially will affect all future hotel developments in Cape May. Let me address our neighborhood. We have 19 residential properties on both sides of the block adjacent to the Jetty Motel. 14 of these properties have undergone either major renovations or total demolitions and new construction. Not one, with no exception, have asked or been granted a single parking variance that includes stacked parking variances or on-street variances.
Most of us have actually increased our off-street parking past the legal requirements. We have done so not because we are altruistic, but because we know the on-street parking problems of our street and the surrounding neighborhoods. We, as a neighborhood, have done our job following the codes so not to infringe on the on-street parking demands at the Cove. On a personal note, because of our positive actions, I find it outrageous for this request for 60 on-street parking variances in an R2 zone. It benefits no one in the public, with the exception of the Jetty Motel. We are not asking you to make it better. You can't put a parking lot down in our area, but we are asking you not to make it worse. Cape May lives under a bubble. I'm not referring to the weather bubble, but the bubble we have instituted ourselves to protect this town from many of the problems facing many other shore communities. I've watched Cape May through the decades become one of the premier vacation spots in the nation. A lot of our success is due to the beaches, the historic nature of the town, and the codes we have instituted to control density. These codes are written to define minimum requirements. This new concept to overdevelop a commercial property, allowing it to bleed into residential areas, is poor planning and will diminish the long-term economic interest of Cape May. We are already having a diminishing residential base. You should ask yourselves, will any potential residents be more inclined to move in Cape May if we go into this direction? For these and many other reasons, you should reject this application. And again, on another personal note, I'd like, aside from denying it, to give you reasons why this is not a good idea for the city. Because I really feel that stack parking for new construction just will destroy a lot of the quality of life and just accentuate the problems that we don't need. Thank you very much.
Karen, I believe you're going to flip the slides for me. Is that what we decided? Oh, I'm going to do the slides. All right.
Yes.
Is this item going to be marked?
I'm seeing it for the first time.
No, yeah, that's, it probably
You
should
have
be.
a program, are you going to go through a bunch of slides?
I am, and I've
All right.
given them to Karen for the record.
Okay, so the slides will be exhibit.
I think,
Yes, I have a number of slides, and
Slides will
I've
be
given them to
exhibit-
Karen for the record.
Okay, well, your last name begins with O, so I was going to use O.
I did that on, I
Your
put my last
name is Obermeyer. So,
J.
J. Alustabor, so it'll be J1. It'll be the entire slide packet, okay?
Sounds good.
Sir, do you swear or affirm the testimony about to give the truth, the whole truth, and but the truth?
I do.
All right, good.
All right. Let's see. Oh, go back a couple. Okay. Given all the confusion, I really thought it'd be a great idea to take a moment and talk about what the real issue is here. There is a lack of public parking in Cape May. It's been documented many times. It's in the master plan. And the lack of public parking has been highlighted as being worse on the west side of town, which includes the Cave. It's clear that this area is zoned for a hotel, restaurant, and bar. The proposed hotel design, as submitted, requires 135 parking spaces and provides 65. I know that's confusing. I would base it on the notice that I received at my house. The developer is applying for a parking variance. This variance is based solely on their ability to operate this as an all-inclusive resort, limiting parking to the guests. Without it being an all-inclusive resort, this variance doesn't work. They're underutilizing the 240-seat bar and restaurant in this model. The developer has the obligation to convince you way beyond, it's a toss-up. This is a long-term decision that they have the skills to do it, that they have the track record of success, and that they can execute it over the long term. That is the question that is on the table. Can they execute this model to receive the parking variance? So let's take a moment and define what an all-inclusive resort is. They defined an all-inclusive resort and described it as being similar to a Sandals or to a cruise. So I went to the Sandals website, got the definition of an all-inclusive resort. It means your stay, unlimited food, unlimited drinks, activities, entertainment are included in the price of booking the resort. That's the definition we're dealing with. I think we need to be really clear about what we're talking about when we talk about an all-inclusive resort. Items typically included in the rate are luxury rooms, food, all beverages including alcohol, lots of activities, scuba diving, paddleboard, jet ski, nightly entertainment. Very typical. During the 3.5-hour presentation and a 100-page application, they presented no information on how they're going to handle all of these other activities and issues. Are they going to need extra storage space? Are they going to need extra staffing? Are they going to be driving buses up and down Beach Avenue to take people to golf courses and over to the tennis club? But even more importantly than that, New Jersey state statute prohibits a set price for all-inclusive alcohol. So we're clear, a key part of their business model is to provide all-inclusive alcohol, and it's prohibited under New Jersey state statute. Now let's talk about their experience. Manny has no experience running all-inclusive resorts. The Inn at Cape May isn't one. So he asked Mike Marshall, the CEO of TPG, to come in and be his partner and talk about his experience with all-inclusive resorts. So I'm going to show his testimony under oath to this fact, to this question from the last meeting. No sound, but there's subtitles.
Rich, subtitles aren't being edited into the record.
It is just, it's already in the record. This is what he said. So he said that we have a handful of resorts there are a handful of all-inclusive resorts, and he highlighted one on Block Island. So I went to the TPG website and found the Block Island Resort, Champlain's Marina and Resort. I then went to their website and found no evidence of it being an all-inclusive resort. So I contacted them. They informed me that they are not an all-inclusive resort. I actually then contacted the Bureau of Tourism on Block Island and asked, do you have any all-inclusive resorts on Block Island? They informed me they do not have any all-inclusive resorts on Block Island. I have a copy of the Champlain's Resort, Marina and Resorts brochure from the internet. I downloaded it. It's clear, it's long, but it does not mention all-inclusive at all. I'd like to share that with the board if I may. So while I continue to talk, I will have
Rich, if I may, I'm sorry to interrupt you. Just very quickly, Rich, and I understand that the rules are relaxed in this setting, but I would note that much of this is hearsay in terms of what the website says, what he spoke.
I believe the brochure is not hearsay.
If we're going to do the technical rules of evidence, they're admissions by a party opponent. I mean, they're your client's own documents. So he's not bringing in a third party's statement. He's bringing in statements by the agent who testified. It's their company.
Okay, understood.
Remember, I'm a trial lawyer by practice.
So am I.
just do this at
No,
night.
I do this same as me.
And another example, this is right from their website. You can see for a beach day package, so if you go to the beach while you're there, you can pay another $170 and you get a towel and a few drinks. Let's move on to market research. This was a big question on the part of the board. Is there any, Karen, you know if there's any way to make the sound work?
We're marking this J2, which is this different than what you showed on the screen?
That is, what I showed on the screen was a page from the website. This is the downloaded version of their brochure, full version of the brochure.
Did you give this to the attorney?
Scott, I don't know if he has one or not. I can't comment.
He should see it before we get it. And you're representing that is the website of the company that's managed by the person who testified?
I am.
This is the first time I'm seeing this, obviously, so I don't know how much time I'll have to review this in depth. But Mr. Mike Marshall is here, and he's prepared to address some of these comments as part of our rebuttal.
Yeah, I would expect so. I would expect some of his comments to change, too. They have before. Let's continue. So let's talk about market research. So the other question the board had a lot of questions on is, have they done the market research to prove that an all-inclusive market, an all-inclusive resort at that site would work? This is Mike's comments on the all-inclusive research. I hope there's sound. If not, you can read the subtitles.
The all-inclusive resorts historically have been found in your sandals, island, Mexico. The concept of moving into the United States, like again, I said, back in the 60s, 50s, and 60s, you had it. The traveling public is evolving in this country, where they're looking for different experiences. Can you point to a town like Cape May where that business model is currently being applied?
It's only up there. But I can't double strain, yeah. So just so we're all clear, at the end, he was asked, can you point to his town like Cape May that has this type of environment? And he said, I cannot. I don't think we want to be the Poconos of the 2060s and say, hey, remember Cape May? They tried all-inclusive in the 2020s like the Poconos did in the 50s and 60s. I don't think that's what we want to be. But now let's turn to Manny and the developer and see what he had to say when asked a similar question about market research.
Do we know if any of this is getting picked up by the record? I can barely hear it, and I'm sitting right here.
In fairness, the packet, the slideshow is in the...
Market research for this project.
Is in...
There's
the
time.
evidence. I can hear what it's saying, and it's matching the...
Okay.
I mean, we know how many people, Cape May County Board of Tourism is an incredible resource for anybody who is in the hospitality business here. They can tell you exactly how many people are going to be here on a given, in a given year.
Once the investor is deciding whether or not to put this money down.
It would be a bank, but yeah.
But what, investor, bank, however you want to categorize it. You said a 5 to 10 year pro forma. What exact documentation in terms of the likelihood of success are you going to provide to them?
It's all market study. So what we did was we took the operational history of the Jetty Motel and some of the Cape Resorts properties that had publicly, their information is public, and our 23-year experience in the Cape May market, and we determined what our occupancy rate.
So if I were the Marriott, the Hyatt, the Hilton, I don't think I'm going to use the Jetty Motel's occupancy rate and operational history to drive my investment decision. I would like facts, I would like numbers, I would like a market study. They had lots of opportunities. They brought in a management team, they have a developer, to talk about what research they had done to prove this would work in Cape May. And all we got is comes from the Poconos, and we're going to use the operational history of the Jetty to develop a pro forma. The last topic I want to cover is the change in operating model. Their operating model changed as the meeting went on. It started as an all-inclusive. Their lawyer got up at the beginning of the meeting, and which will be the first clip, and said, the reason this application is different from any other application is because we are proposing an all-inclusive resort. And you'll hear how the then you'll hear a description of the operating model as a cruise, then you'll hear a change. And I just want you to all kind of pick up on that.
This is proposed to be an all-inclusive luxury resort-style hotel.
All right, when you make a reservation for a cruise line, whether you go through a travel agent or through them directly, you pay in advance. When you arrive at the cruise ship, they hand you a set of keys or a key fob to get in. That's your passport to get through the ship. Once you have that, that's how you charge everything. They typically ask you to provide a credit card for any incidentals, which might be an extra drink at the bar, or to use at the gift shop or the spa or what have you. This is the same concept.
The idea of separate kind of packages in terms of if people would prefer to eat off-site, they could pay a lower rate in terms of, because they're not actually, it kind of varies based on what the guests want. Is that correct?
There will be options, but the options will be priced to try to push them to do as much on property as possible, because we're saying we're giving them options. You don't want to have dinner tonight, then we'll give you a credit for that. You don't want to have breakfast today, we'll give you a credit for that. You can still go out and enjoy whatever you want to enjoy.
So my take on this is, we started the meeting at an all-inclusive, with proposing an all-inclusive luxury resort. At the end of the meeting, we ended with a college dorm with a meal plan and a cash bar. It's a big change. Those are significant changes. And tonight, they got up and said, it's all-inclusive. I was the one who defined all-inclusive. I don't think they ever did. Shouldn't have that been the first thing they did?
This is proposed.
They also have a long-term, this is not a new thing. We've been talking about this 14,043 square feet since I have owned a home in Cape May, starting in 2018. At first, in 2019, with the Jetty Hotel, we're just going to leave it blank. We're never going to use it for anything. In 2021, we're going to have a bar that's open to the public, bar and restaurant that's open to the public. Our business situation has changed. It's pivoted, which I believe is one of their favorite words. In 2025, we're talking about an AVU, all-inclusive resort, where it's going to be limited to all-inclusive guests. This change, I put what's next based on the fact that everybody's here and I'm looking over there. I'm not sure there won't be a 2025B before we leave the meeting tonight. So in conclusion, the management company and developer have not presented a track record managing all-inclusive resorts. They did not provide any details on how they would run an all-inclusive resort in Cape May. No market research, no information on similar resorts that have been successful. They seemed unaware of the prohibition on offering unlimited cocktails at a set price in New Jersey, and considering they currently have a liquor license, they should be aware of that. And last, their operating model changed during the meeting. Based on the fact that the developer has not made a case that they should be trusted to run an all-inclusive resort, nor have they made a case that an all-inclusive resort will be successful in Cape May, the planning board needs to base their decision on the difference between the 135 spaces in the proposal and the 65 or 55 or 42, whatever number they come up with that they can provide. Thank you very much.
The board secretary has a exhibit.
And so we're gonna start by saying your name,
Right.
spelling it, and then.
Craig Versteeg, Versteeg.
First name was Craig.
Craig,
How do you spell Craig, C-R-A-I?
Craig, 14 Second Avenue.
Okay. Got another show?
It's passed out.
This will be C1. But this council, okay.
All this is, well, I guess I have to be sworn in first. I'm sorry.
Oh, Rich, yeah, we should swear.
This is much simpler than previous.
Sir, do you swear to tell the truth, all the truth, nothing but the truth, so help you God?
I do. This is just in lieu of a field trip. That's all this is how I feel about things as a neighbor. And all these pictures are, or so we can see, because when I look at the PDF with the numbers on the easement driveway, 20 feet, 21 feet, 25 feet, the different things that they're plotting on their plan, I just need to go out and take a look at it. So that's what that's for. All right, our home, which is both our second home and our rental property, sits directly next door to the current motel, shares the length of the property line, as you can see, with the easement being discussed. When we purchased in 2018, there were approvals that we discussed for the 33-unit version without the bar, restaurant, and rooftop pool, without the attendant variances, congestion, and parking issues that we're currently discussing. We recognized it then as a very common sense development for both the jetty and our neighborhood, which is a residential and commercial area. With this newer plan, I have very large concerns for the fit for the area, as been discussed before. Number one, I'll just address the number one thing I have, just the congestion that we've all been talking about, particularly looking at that easement area. And I know my tape measure is not perfect, but I will point out that the survey pin is on the jetty side of that white masonry wall that you see. It may be less than that. It may be 3 to 8 inches. It's been a while, but it's somewhere around that flower pot, maybe a little closer, but the end point is 25 feet, and it's approximately the bumper of that car. And I just want us to stare at that for a minute, because I'm not sure where that new wall that's going to enclose this inside parking leading into this loading dock is actually going to finish. I'm sure they can address that more appropriately, because the feet and the starting and ending points are on their plans, okay? But our house does adjoin it. I've talked about the 25 feet. The proposed changes in the footprint will at least move out into that car. Flip the page. At least somewhere into that. I'm sure they can discuss that. I just know that that loading area is going to start moving in. We've already talked about that, to that 25-foot area we just saw, okay? To me, that's going to squeeze and tighten that whole area. Many additional truck deliveries required by a restaurant bar that size. I said at all hours, but I've heard it's going to be business hours. That's good, because it'll be different than the Wildwood Linen truck at 3 a.m. the other night. Will affect everything from our rental business to access to my own driveway. If trucks have to wait, if they have to wait to get in on 2nd Avenue, they will most assuredly block my driveway, which is 50 or so feet away from the picture we're looking at there. Double parked. I experienced this as a condo owner on Jackson Street, across from the Mad Batter. However, that area of town is commercial and residential. We all know what we're getting into on Jackson Street. I believe 2nd Avenue is a little different, meaning residential and commercial. Adding the full-service hotel, restaurant, bar we've been talking about is very different on this end of town. It was not part of the plan I saw when we purchased. A large truck looks to me like it's going to need to back into this smaller, tighter space. I used to work at UPS, the 40-footers or maybe even the 26-footers heading in on that radius I saw on the plan, it looks like it seems almost impossible to me. I said it looks. Maybe it is. I see this possibility daily outside my southeast windows. Bigger trucks either have issues or, like the Wildwood linen trucks I often see, they don't even go back there when they can. They just sit out in the middle of 2nd Avenue and unload. That's why I think they find it good to use the off hours. That's with the current size driveway and no loading dock. With the proposed changes, it just doesn't logically sound to me like it can safely handle the new delivery traffic that we're about to have. I also am not sure you can actually logically add street parking to that final picture, the street scene, because as I recall back on our condo on Jackson Street, there was no parking right there because they did have to jockey, and still do, have to jockey those trucks as they pass each other on Jackson. I know this street is bigger, but if we constrict it by, in the summer, all those cars on both sides and add waiting delivery trucks, we may have a problem. The last one is groundwater. And I only have to say this from personal experience. I know stormwater requirements are met in plans. I am simply giving an experiential heads up for the board's attention. On the plan is an underground drainage trench and infiltration system between my property and their planned hotel. It will certainly add to a drainage area which was constructed already under the easement driveway in some time after we purchased. The water that percolates in there, and I know that's in code, I'm not debating that, but it does directly flow in a direct line through my property on its way to the Mount Vernon storm drain under the ground. It's like an underground stream. By 2020, following the construction changes behind me, okay, we had markedly more water to get rid of. The city allowed me to pump water into the street. Temporary at best. It was a neighborhood problem. The better solution last spring came with some welcome suggestions by Mr. Dietrich and my contractors, and we spent approximately $7,000 to put a large water storage pit in the front yard. That seems to be working. It flows underground from the direction I mentioned into my basement out to our new pit. It helps alleviate a neighborhood problem that did not exist to that extent in 2018 when we purchased. I know what the plans say. I'm good. But I'm just asking that we all work together here. I don't believe that my family should have to remediate again due to new drainage changes. So we feel like there has been, and there still has to be, a solution that would be profitable and benefit all concerned. But this one, already almost without question the same one as previously voted down by this board, is not it, in our opinion. Thank you.
Good evening. My name is Paul Johnston, Johnston. My address is 405 South Beach Avenue. I'm the direct neighbor of the J Motel. I'd like to ask the professionals a question concerning the pool deck. The pool deck is not an accessory use. That was established. My question is, and also I believe was established, was the pool deck is not part of the floor area ratio. So does that mean that the pool deck is open space, considered open space? Yes. Is the pool deck considered open space? Just like the front yard setback or the side yard setback?
I can't answer that question.
No, it's a structure.
Yeah.
The structure. So it's included in the floor area ratio.
Floor ratio is for residential uses.
Okay, well, it's part of the structure. It would be the same thing. It's not considered open space. Would that be a correct statement? It's not considered like the front yard setback.
I want to answer your question accurately. Open space is a whole different concept in zoning, so I don't even know how to answer that. I'm sorry, I'm trying to give you a hard time, but you're asking me for definitions, and those are words that mean certain things in zoning.
And
Like,
that-
you ever hear of open space? I mean,
And that's why I said I can't answer.
Well, my
Oh,
question is, the H2O in the pool deck and the H2O in the pool, I think back in the 70s, the pool area was considered open space, similar to a front yard setback, front lawn, rear lawn.
Okay, I think you're
That was-
creeping up on,
that was an
I think you're
exemption.
creeping up on lot coverage is your question. And you're asking whether
Right.
the pool area counts toward lot coverage, and the answer is yes.
Oh, okay, the pool area is considered lot coverage. Okay, that was my
Yes.
question. Thank you. My second question is, at the last meeting in April, there was discrepancy among the professionals, the engineer and the architect, concerning a weight-bearing wall on the north elevation of the parking garage. The architect said there was no weight-bearing wall, and that the two spaces, which appeared to be stacked, but he said one space would enter and exit the driveway alongside the north area, along Craig's house and Mark's house, that easement. And the engineer said, no, there's a weight-bearing wall there. So those spaces would be stacked. And then the architect said that the architect's plans govern the application. So and then later on, there was a parking space discrepancy. And today they said that they have, first they said they have 79, 21, no, it's 22 stacked spaces. And they have, let me see. They have 57 non-stacked spaces. So they have 57 non-stacked spaces, and they have 56 rooms. So that leaves one room for an employee. And the rest are stacked. So they need a parking variance for my calculations for 78 parking spaces. They're short 78 parking spaces, based on my calculations. Not 65 or 60, but 78. That is a lot of parking spaces to be on the street. So that alone, I think Mr. Hurlis said early on, this application lives and dies by the parking variances. Well, 78 parking spaces, the 78 parking space shortage is an awful lot. So based on that alone, it should be denied. Okay, another thing I want to say is the developer is asking for a parking variance. Yet, back in 2005, I believe, he sold 2 lots in the back of his property. It used to be a parking lot. He sold 2 lots. And so he has approximately 30 spaces short after selling his lots. He sold it for a profit and he developed it. So in essence, he created his own hardship. His hardship is self-inflicted. So just want to put that out there. Another thing is that the previous plan someone referenced to, I think Craig did back here on 2nd Avenue, when he first bought the house, there was plans approved, and one of the plans approved was for a second-level parking garage. You had the ground floor parking, you had a ramp going up for another additional 12 spaces, I'm not really sure what it was, and that was approved. Then later on, he came back and he eliminated the 12 spaces on the second floor, eliminated it, and put it in a bar restaurant. So again, he created his own hardship, eliminating parking spaces. He created his own hardship. His hardship is self-inflicted. He did it to himself. He sold the parking lot in the back, and he removed a approved
Johnson, I'm being told that
second-level parking garage.
Mr. Johnson, I'm being told now we have a 5-minute.
I'm sorry?
You're past your 5 minutes now, okay?
Okay, well, I like the same treatment as everyone else.
I understand.
Okay, I'm done. That was my 4 points. And any questions? Anybody have any questions? Anybody want to rebut what I said? Challenge what I said? Thank you.
Just to briefly answer that question, the applicant has reserved the right to present rebuttal testimony.
Before things get handed to my board members, hold on, give it back. You got to show it to the attorney, and then he can tell me if he objects to it, okay?
And again, the applicant has reserved the right to present rebuttal testimony, so I'm not going to be rebutting every single person after that. That's just not time.
Just show him what you're showing
Show
us.
him, you want to show the solicitor there.
My name's Mark Renna, 12 Second Ave. I just have one question. Every time I look at their applications, I have to file an Oprah and stand in a corner and review it, but I have to give them my information?
You don't have to give them anything. You can go back to your seat. I don't know what you're asking me. I mean, I have to make sure it's admissible, so he has to see it, and then I have to see it, and then we have to decide if it's admissible, because if it's not, the board shouldn't see it.
Okay.
But once I show it to them, then there's no point in doing the analysis. So that's all.
I don't, you could, sure.
And I would just note for the record, this is a several-page document that I was just handed now, so I haven't had an opportunity to review this.
May I begin?
No, hold on a second, please. All right, these are numbered. Number 1 is an agreement for a driveway, although it looks like it's only one page.
I can explain the documentation provided. It is very hard to review an application that's chock full of information. It's impossible to review an application that does not include
Sir, do
information.
you swear, please state, hold on one second, you're going to talk, you're determined to talk before I look at this, so let me just get your name and your address and do it that way.
My name is Mark Renna, R-E-N-N-A, 12 2nd Avenue. That's the house on the lot that was just referred to by Paul, that my house is accessed by the easement across the Jetty Motel.
Okay, do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Okay, do you want me to do these documents first, or do you want to talk first?
I want to talk first. This will go rather quickly. You may or may not look at the information that is numbered 1 through 12 at your discretion as I rip right through this.
Is this going to be marked? I'm guessing the whole pack is R1.
I'm not going to mark it yet.
Okay, fair enough.
He hasn't asked me to show it to the
Fair
board.
enough, fair enough.
We support the Jetty Hotel's approved proposal of 2018. We were well aware of the project when we bought the house in 2020. The renovated hotel would be a great improvement, and I told Manny so when we closed on the house. However, we do not support the revised proposal as it adds a restaurant and bars, and while it's similar in footprint, the impact associated with the use is dramatically different, far greater and intensive. Our driveway is our only access to our property. It is correctly depicted on the application as 25 feet wide. It's 130 feet long, and it's been corrected on almost everything except has been noted by the engineer, some of the Fenwick architectural plans. In the application, attachment 1 is the 2011 easement. However, what's not included is the 2020 amended driveway easement that was put in our name and Manny's name. The only use of the driveway easement is exactly that, as a driveway easement. No other permanent encroachments are permitted. Attachment 3 shows the loading area that's been referenced, 12 by 55 on top of the 25-foot wide easement. City engineer's report notes that, but also doesn't note that in that easement, the plans note this, that South Jersey Gas has a 10-foot easement within the 25-foot easement. In the testimony of April, the city, in the city engineer's report and the letter from the applicant, they have focused on a phrase in the easement of a non-exclusive easement, which we recognize and agree with. But approval of a loading zone within this easement would be an exclusive, designated, and permanent encroachment, not a non-exclusive use in a shared driveway. Some of the photographs I showed in attachment 5 were probably very similar to what Craig just showed. What you may not know is that I'm required to insure the easement, and the Jetty is 100% required to maintain the easement, and they don't always. So in attachment 6, you will see a code violation from the city issued May 20th. There's been some discussions of environmental impacts, the needs for an EIS. And the DEP has jurisdiction too, that has just been described. Consistent with that, there's a minimum need of the EIS or a CAFRA compliance statement. Again, the direct impacts are very similar. from the 2018 proposal. But the increased intensity of use of traffic, air emissions, noise, lighting, land rights encroachments, and safety are all environmental issues in need of quantitative analysis, which hasn't been done. An EIS must address impacts, mitigation. The impacts have to be categorized as direct, indirect, and cumulative, and the project will impact many of those issues. This may seem very small in attachment 7, but there are 12 cedar shrubs there today and 1 pine tree. Yet somehow the Environmental Commission and Shade Commission says there's no vegetation on the property today. And in the proposed plans, those are to be removed and replaced by holly trees, ilex, as indicated on the landscape architectural plan, which seems like a waste of one native species to another. I mention these because it seems small. They may seem small, but there are omissions and incomplete information in this application that doesn't address all of the cumulative impacts. For example, a restaurant will have air quality impacts with emissions from their venting fans. Noise. Will there be live or piped-in music from this rooftop bar? What's the impact? What's the cumulative noise impact with the music at the nightly flag lowering ceremony at the pavilion? What's the effect on the oyster catchers as they make their sunset territorial calls and round the cove before settling down in the South Meadow Preserves? The beach. This is described as an all-inclusive, as has been mentioned by Jay. A beach shed, chairs, lounges, umbrellas, cabanas. There will be twice as many guests at this hotel, and the DEP requires a permit for those tourist attractions. It's a general permit number 22 on top of the individual permit. But speaking of the individual permit that was granted in 2018 and expired, the DEP in attachment number 9 denied the extension. I'm an environmental scientist with 40 years of experience, and I obtain DEP permits all the time, including extensions such as this. This permit extension was denied, and as a result, a new CAFRA permit is required. What's very odd about the applications, when I looked at the 2018 to 2023 applications, is the way the required line on the DEP application form was addressed the topic of easement holder. And I would draw your attention to page 2, where you can see that it says signature of owner / but there are no words after that. And that is because the words easement holder have been removed from a state permit application. I support that assertion with attachment number 11, which is the same form, which shows that the words easement holder after the / still exist. But if you go back in time to 2018, when Mr. Demutis was the only easement holder, he had no issue signing that line after the / as the easement holder. So what's happening here as we bounce between DEP and the city is a misrepresentation of who is or isn't a legal easement holder. I've submitted all of this information to the DEP already. The DEP has already responded. As has been testified, a new application is required, and it has not been applied for as of yet, but it will be required. So I'm sorry that this took a bunch of time, but there's going to be a whole bunch of considerations for the city that cross paths with the DEP. So the current proposal and its increased impacts, we oppose. And frankly, if passed as prologue, we're going to be here in 3-year increments until the FOB system is supposed to be done away with, because the business model isn't going to work. And in Greek mythology, I'm sure you're all familiar with the idea and the concept of the Trojan horse, a gift that was wheeled into a city, but was not what it seemed. But I don't think we all know it's that horse's name was Fob, or Fib. Thank you.
Edward Johnston, Johnston, Edward or Ed, E-D. I'm an owner with my brother and sister of the Cove Restaurant, 405 Beach Avenue, west end of Cape May. I can tell.
Swear or affirm to tell the truth, and nothing but the truth?
Yes, I do. Okay, I'll be brief. I just think that the requirement and the variance they're asking for, I believe it was 65 parking spaces, that they're short, is just preposterous. I mean, I don't get it. I don't understand it. The idea of an exclusive resort in Cape May, I don't get it. I don't think it could be enforced. I don't see how you can enforce it. You know, we had a problem last summer with a beach employee feeding the seagulls, and we asked her boss to tell her to stop. She wouldn't stop. We asked the police to tell her to stop. She wouldn't stop. At the end of summer, we took her to court, and in the winter we took her to court and we won. The judge told her to stop. And then a couple days ago, another beach tag girl was feeding the seagulls. So I don't know how you enforce laws at Cape May. People complain about dogs on the mall all the time. That's all I hear, dogs on the mall. How are they going to enforce this? I don't get it. The only benefit I see to this proposal is to the owner of the jetty, not to the community, not to the neighborhood. And from what I understand, the owner of the jetty lives 125 miles away. So if there's a problem down there, I don't know who's going to fix it for him. How's he going to manage it? In my place, when I hear complaints, I'm there 7 days a week. I think he's putting like 25 pounds of potatoes in an 8-pound bag. I grew up in that spot since I was like 9 years old. Every year it gets more congested all the time. Traffic gets worse. Now we have sunset ceremonies, which is nice, but it used to be that used to be the quiet area of town. It's not anymore, and it's just going to get worse if this plan is approved. It's like Alice in Wonderland. I don't get it. I don't understand it. My brother mentioned the fact that 15, 20 years ago, he had those 2 lots in the back on the west end of his property that he sold. He sold to another guy, and now there's a house on there. Those 2 lots could have been parking. So, in effect, he created his own hardship. And I just think this plan is just Alice in Wonderland. I don't get it. So that's all. Thank you.
Good evening. Christopher Hall, H-O-L-L, 17 2nd Avenue.
Was that H-O-L-L?
H-O-L-L, that's correct.
17 2nd Avenue?
17 2nd Avenue.
You swear or affirm to tell the truth, whole truth, nothing but the truth, so help you God?
I do. I have 2 issues regarding this application, amongst others. As far as the number of employees listed for the restaurant, which is 2 wait people, 2 cooks, a dishwasher, and a bartender, in my opinion, that is not nearly enough to adequately service the guests with approximately 200 chairs. It seems woefully short. When I had my restaurant, which had about the same number of chairs, I had 26 people per shift on payroll during every shift. Secondly, I want to deal with the reality.
Hold on.
Excuse me.
Show it to council, give it to me, and then we'll pass it around.
Sure, trucks.
It looks like it's just a picture. It's not a big deal, but I just want to. What do we got?
It's a picture of trucks.
It's a picture of trucks.
Pass it around. All right, so that'll be,
I don't know where it is. I don't know.
CH, well, that's for him to do. It's
Yeah, okay.
CH1.
This is the reality of dealing with the restaurant. The reality of the traffic disruption that will occur with this restaurant, as we know. As we know, 2nd Avenue is a 2-way street. Parking on both sides all day long. People with children are headed to and from the beach, carting their beach needs.
So, sir, can I just interrupt you real quick? You handed a picture out, and can you just identify what it is so it's authenticated? I think it's Oyster Bay, but I don't know.
It is Oyster Bay.
So
It's Oyster Bay, and I have 3 trucks being delivering
Okay, thank you, sir.
at the same time, naturally. Okay, so we have children headed to and from the beach, carting their beach needs. The children run ahead and lag behind their parents. There is also a parade of bicycles to and from the beach. Cars continually circle the block looking for parking. If this plan is approved, we will see a significant increase in an already congested corner. You will have a great number of delivery trucks trying to access the loading zone by backing in or out of 2nd Avenue, most of which are semis or large box trucks. When 2 or more trucks are trying to make deliveries, 1 or more will have to double park. One direction of traffic will essentially be stopped. The National Transportation Department statistics state that 110 children are injured by cars and trucks leaving parking lots weekly. 70% of them are from large box trucks. Given the amount of foot, bicycle, and auto volume that currently exists, one would have to conclude that increasing the volume in this proposal will provide a chaotic and a very dangerous situation. Thank you.
Anybody else within 200 feet of the property wish to be recognized? Anybody outside the 200-foot area can step forward now. You're within 200 feet. Go ahead, sir.
Chris Johnson, CHRASJOHNSON, at 305 Beach Avenue.
Sir, do you swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you.
Okay. My neighbors, some of them with expertise, have just done an excellent job of explaining why there are so many holes in this application. They've also done a wide degree of research to show that the application doesn't hold water. So my comments are simply, this really is fairly simple, okay? It doesn't hold water, and you should reject it. Thank you very much.
Anybody else within 200 feet like to speak? Anybody else in the audience like to speak about this application? Come forward.
Joseph Milligan, Milligan, 30 First Avenue, right around the block.
Sir, do you swear or affirm the testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God?
I do. An all-exclusive resort, unless you're the person that gets there halfway through the parking spot's all gone away. Then you have to find a place on the street. I don't understand that as being part of an all-exclusive resort. But that being said, you've heard the parking issues, the increased congestion, the traffic, the noise, the adverse effects on a limited access residential section of Cape May. Once you, the board, allow this to go through, there's no going back. The character of Cape May will be changed and will continue to change, not for the better, because you've set a precedent. The beachfront will transform into a high congestion, high-rise, greed-driven business sector, much like Sea Isle City, the Wildwoods, Asbury Park, and Ocean City, Maryland, where the partner runs a high-rise complex in Ocean City on the beachfront. We will no longer be the #1 beach in New Jersey, the premier summertime getaway, recognized for our charm as a coastal escape. Our future is in our past, as stated on our own promotional literature. To say that this type of development is the only way Cape May can prosper and move forward is being morally incompetent, cowardly, and lazy. All of this can be moved by the beauty and serenity of the cove area and our coastline. We should rise above the greed and the contempt of its exploiters. Thank you for your time.
My name is Jane Lester. It's Jane and I live at 26 First Avenue. My husband Bob and I own the... sorry.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Sure do. Thank you. My husband Bob and I own the Red House on First Avenue since 1996. And we have seen much construction in our neck of the woods since our entry into the community. We're watching existing buildings grow higher or being torn down, replaced by buildings expanding to the boundaries of their property lines. We have also witnessed an increase of traffic during vacation months to the point of being dangerous to walk or ride your bike. We miss the Mount Vernon, as it was a neighborhood landmark. What remains now is the jetty. It's another neighborhood landmark, a piece of Cape May history dating to the times visitors just wanted to look at the ocean and have a clean bed to sleep in. I know some of those visitors still exist, as I see them sitting out next to their rooms with blankets on in the cold winter months. I usually like things to evolve, but not in this way that is proposed for this property. I ask that a plan be revised to be a luxury motel. Fix it up, make it look nice, instead of an all-inclusive hotel. We don't want it here, nor how it would change the landscape of our community in this area of Cape May. Thanks so much.
Hi, my name is Chris Hein, H-E-I-N. I live at 7 Swan Avenue in Cape May.
I'm sorry, was that Chris Lane?
Hein, H-E-I-N.
H-E-I-N, okay, thank you.
I swear to tell the truth, so help me God.
Thank you, sir.
Those might initially, when I say where I live, wonder why I'm wanting to speak. But I want to speak because in Cape May, what affects one of us
Speak into the
affects
mic,
all
please.
of us.
Can you speak into the mic? We can't.
Yeah, we're just having, you're kind of call.
I'm here because when we do something for one, to one, we do it to all here. While I don't live right in this area, this certainly will affect all of Cape May. The first thing I want to address is the legal standard for a variance. The legal standard for a variance is either there's a substantial benefit provided to the neighborhood. No one has alleged that or acknowledged that tonight, or that there is a hardship. A hardship, a classic example of a hardship is you have a piece of property that is undevelopable unless you get a variance. It's a hardship. The jetty has existed for decades. It wants to double its size or more. Unrealized profits are not recognized as a legal hardship, and this body needs to address that the standard for a variance here has not been met. The reason I say that is behind these gentlemen is another gentleman who wants to put an 8-story hotel in the center of town. He is looking at this tonight, and he's going to see somebody get a variance for 60 parking spots, and he's going to take that as an order of magnitude of available variance to be treated similarly. This is a precedential value, a precedential time for the town, and you must deal with it very seriously. The second thing I don't understand is I want to debunk this idea of an all-inclusive. This is not an all-inclusive. If anybody has stated an all-inclusive, they'll realize this is not it. In an all-inclusive, you show up, your drinks are included, your meals are included. You can leave the property if you want, but you don't get any money back. If you don't use the resort capability, you don't get any money back. That is not what these people have testified to. This is no different than any other hotel in town that'll give you a free breakfast or will give you a voucher for use in their hotel. There is nothing unique about this that makes it an all-inclusive, and there's nothing in our code that I'm aware of that deals with anybody who claims to be an all-inclusive any different than any other hotel use. He must be treated that way. Lastly, the accessory use, and I respect your solicitor, and I respect his advice. I disagree. I think that any use that supports the primary use of being a hotel is an accessory use. That would include the restaurant, that would include the bar, that would include the pool, that would include the area around the pool, which is going to be used for lounging, it's going to be used for eating, they're going to deliver stuff to people eat there, they're going to have functions there, they're going to have umbrellas there, it's going to be used. I don't hear anything tonight in what was read that accessory use requires it to be enclosed. It's just area used as an accessory use or a subordinate use to the primary being a hotel. So that pool area should be included, the pool deck should be included, the lobby should be included, the hotel restaurant should be included, the bars, the library. I would like to know what restrictions are on a library that it's not a library until 4 o'clock and then it becomes part of the restaurant or becomes part of the bar. What makes it a library? I've been to a lot of all-inclusives. I've never seen a library in an all-inclusive. Certainly never seen a book and never seen anybody sitting there reading a book. But what I have seen is something called what gets it through the zoning ordinance, and once it's opened, it becomes something else. You have a unique opportunity here to avoid this thing being considered something today to get through zoning ordinances, but then is used for something totally different afterwards. And along that line, I want to know if the town is going to say that there is a difference about an all-inclusive and the public will be excluded, what are the ramifications, what are the restrictions that are going to be placed on this hotel so that when they start taking public members into the hotel, and they will, because the people in the hotel will be going out to see all the other restaurants in town, they're going to need to fill those seats. What is the town going to do when they start allowing the public into there and parking and that people want to come in and use the restaurant without the hotel? So I think this is a situation where the town has a unique opportunity to evaluate this as to what it is, what's being sold as today, and what it could be used as once the spotlight has been turned off. And I think you need to take that seriously because, like I said, there's another gentleman that's looking to put an 8-story building in town, and he's going to use every argument you've heard here tonight and in all the hearings before this as to why he should. But he's going to add one. You let the jetty do it. You have to let me do it. Otherwise, it's discriminatory. So I hope you'll consider that.
My name is Richard Fellows, Fellows, 834 Washington Street, Cape May, New Jersey.
Swear or affirm to tell the truth, whole truth, and the truth, so help you God?
I do so swear. I noticed that the application didn't address water or sewer use capacity. Will the water and sewer permits from the department do that, or are they just going to check the plumbing? Well, to anyone.
What I recommended is that any application similar to this that has a new water and sewer connection has to ultimately get water and sewer department approval for this. So they're aware of their capacity and whether there's availability. So that's part of that review process. So that would be, if the board were to grant approval, would be a condition of approval.
And they're going to evaluate capacity.
They have to. They can't allow someone to connect into their water or sewer service without having the adequate capacity to accommodate whatever the proposed use is.
See, therein lies the rub. As you know, many years ago, Cape May City ran out of potable water. And we made the regrettable decision to desalinate an overused aquifer instead of other options. And the more you overpump that aquifer, the saltier it gets, the more expensive it gets to desalinate it. The byproduct of that process is a toxic waste. It's got to be handled specially, transported specially, and disposed of specially. It's expensive. The more you do it, the more it's going to cost. And that will be a burden borne by every resident of this town. Now, you might not consider this germane to this particular application, and you might not even consider it to be within your purview, but it should be. Our desal system here is a ticking bomb, just like everybody else's. And it's got to be addressed. Looking at the application without any capacity numbers, it looks to me like they're going to about maybe double their water use. A place like this uses water more than a hospital does. Hospitals don't have swimming pools either. So it is an impact to the entire community. It's a detriment. We have an infrastructure deficit. Just like roads, just like parking, just like all the other things, all the services. And in my opinion, this is a serious one. So I urge you, if you're able to take it into consideration. And I urge City Council to have some discussions as soon as they can. Thanks.
Anybody else wish to be heard? Because we're going to try and take a 5-minute break here. Okay. 5-minute break, everyone.
I think he's going to be last. Is anyone else besides?
Hold on, please. I think you wanted to be last as far as...
Yeah, it looks like that.
Anybody else in the audience wish to speak? Okay, we're good. We're going to break 5 minutes, and then you're on. All right, everybody, can we try and sit down again, please? Let's try and get this thing started again. All right, everybody, can we sit down, please, so we can get started? I appreciate everybody working with us on this. So we'll have this, we'll have someone testifying now, and there's probably some rebuttal by the attorney, and then we'll move on. Go ahead.
Thank you, Mr. Chairman. My name is John Amenhauser. I'm an attorney with the DeWeese Law Firm. I'm here tonight on behalf of multiple objecting parties, namely Dr. Scott Maslow and Bobby Stokes. They're at 18 2nd Avenue. Joseph Slitcher and Nancy Slitcher, they're at 19 2nd Avenue. Craig and Lisa Versteeg at 14 2nd Avenue. And Jay Kloosterboer and Barbara Zakari at 25 2nd Avenue. The record tonight is already voluminous, right? Anything I can say right now, factually, you've already heard it. So just to briefly and succinctly put what the legal standard is that you have to evaluate this application under, the applicants come before you tonight seeking site plan approval and variance relief under what's known as the C2 substantial benefit criteria. It's a balancing standard. What they're seeking is a variance to allow parking up to 79 parking spaces with 57 standard spaces and up to 22 stack spaces where otherwise 135 spaces are required by ordinance. In order for the board to consider granting that variance under the C2 criteria, there's 5 elements that have to be met by the applicant. I'm going to go over those 5 now, but before I even do so, I'll concede that we believe that the first prong that I'm going to go over has been met by the applicant. Namely, the applicant's got to show that the purposes, the applicant has to show that the application relates to a specific piece of property. It does, right? They've identified the piece of property that this application pertains to. They've met criteria number 1. 2 through 5, which I'm going to go over now, the argument that we would make is they have not met them in any way, shape, or form. Second, the applicant must show the purposes of the municipal land use law would be advanced by a deviation from the zoning ordinance requirement. Third, the applicant must show that the variance can be granted without substantial detriment to the public good. Fourth, the applicant must show that the benefits of the deviation would substantially outweigh any detriment. Substantially is an operative and key word there. Does what they're proposing substantially outweigh any detriment that would befall the public good, the neighboring community, and the property owners that I represent this evening? Fifth, the applicant must show that the variance will not substantially impair the intent and purpose of the zone plan and zoning ordinance. So as I mentioned, we believe that while number 1 has been met there, 2 through 5 are not in the record. In fact, although the case in chief was put on mostly at the April 8th meeting, the first time around here, as my client's professional engineer and planner and I sat here, I can't recollect either tonight or back to April 8th that any purposes of zoning that are believed to be promoted by the applicant were actually ever placed on the record. So without that, the testimony that they provided is woefully void in terms of providing you with criteria that you could utilize to potentially grant the requested relief. Now, in addition to that, the New Jersey Supreme Court in the case of Kaufman versus Planning Board for Warren Township specifically stated in their opinion, no C2 variance should be granted when merely the purposes of the owner will be advanced. The grant of approval must actually benefit the community in that it represents a better zoning alternative for the property. Once again, you've heard this a number of times tonight, but I'll repeat it. I believe that the testimony placed on the record by the applicant, that both on April 8th and tonight, shows that the only benefit that would befall anybody if this were granted would be for themselves. They haven't shown that this is a benefit to any other property owner in the neighboring vicinity or the city of Cape May as a whole. Based on that, and I said it was succinct, right? I feel like I should stand up here for a really long time. But it can be boiled down in terms of the relief requested and what you have to consider in addition to the facts when determining whether or not you're going to grant this. We do not believe that the requirements of the C2 balancing test have been met here. We'll concede the first, but we will not concede 2 through 5. And additionally, we believe that the case law established by Kaufman versus Planning Board of Warren Township by the Supreme Court suggests that because the only benefit that befalls anybody here relates to an advancement for the applicant and not the general public, this should be denied on those grounds as well. That's the legal argument of the applicant. But as I mentioned, the applicant or the objectors, not the applicant, have retained the services of Brian Murphy. Brian's a professional engineer and a professional planner with the firm of Pannoni Associates. You've heard a lot of testimony from the applicant's professionals tonight, and you've also heard a lot of testimony from objecting parties and myself, but you haven't heard from any third-party planners or engineers to be able to rebut the testimony put on the record by the applicant's professionals. We'd like the ability to do that now, and I have Mr. Murphy here with me.
Mr. Almazar, before you turn it over to Mr. Murphy, I want to ask you a question.
Yes.
Do you believe your client, the one with the challenging last name, Klusterbor?
Jay Klusterbor, yes.
Klusterbor, said that he believes the critical issue is whether or not the board is convinced that the business plan of an all-inclusive resort will be a successful business plan, and whether it's been established that it'll be a successful business plan. Do you think that it's appropriate for the board to consider that analysis in making a zoning determination? Can they say that we don't believe that this business plan will work and therefore deny the variance on that basis?
I do, and the reason I do is based solely on the proposed, I got to be careful here, not the proposed use, right, because the use is a hotel, but the style of usage and this all-inclusive argument. If it weren't for that, then I don't think there's any real rationale for Jay to utilize to talk about whether or not the business model of a hotel would survive here, right? They're permitted uses. But the fact that they're trying to limit it to a particular type of hotel use, that being all-inclusive, I most certainly do think it's appropriate to consider that when you evaluate whether or not to grant the requested relief related to parking. On top of that, too, Mr. Solicitor, I just want to note, in relation to Mr. Klusterbor's testimony earlier, he did reference an administrative code regulation that I also think is pertinent here. Not really a planning consideration generally, but again, because of the intended nature of this resort as being all-inclusive, particularly including providing alcoholic beverages, I do find it to be a factor to be considered by the board. What Mr. Klusterbor was referencing is administrative code regulation for the Division of Alcoholic Beverage Control. Citation is Chapter 13:2-23.16. And what it specifically does, aside from a set of two very specific circumstances, is it prohibits a license holder from offering an unlimited option for consumption of alcoholic beverages on any licensed premise. The only two carve-outs to that relate to specific, call like a corporate event, one that might be held with an open bar for someone to utilize. And the second is cash bars on New Year's Eve. For whatever reason, that's included in there as well. They're the only two carve-outs to the prohibition on providing unlimited alcoholic beverages on any license holder in the state of New Jersey. He provided it to me, I looked into it, and I agree with his position on that. So I wanted to cite that for the record.
Does all-inclusive have to be unlimited?
I believe all-inclusive is unlimited, based on the definition that was provided by my client and that which was originally put on the record by the applicant. So I just wanted to reference that.
You pay for 10 drinks a day and say that's all you can have is 10 drinks a day. I don't know that this is...
I don't want to confuse the issue. I really just wanted to cite to that specific standard and make sure the record's clear as that it exists.
What was that citation again?
It's NJAC Chapter 13:2-23.16, and then specifically subsection 1A.
Okay, I just asked my board, if you're going to deny this, don't deny it on that basis. I'm not comfortable there's enough in the record for us to do that analysis. There's no expert testimony, and I just...
You're talking about the liquor analysis, correct?
Yeah, the liquor thing. I mean, I'm not saying it's irrelevant, but I'm just saying if you're going to deny it, I think that is I don't know that the record would, I wouldn't be comfortable denying or granting it based on that analysis. You're not going to do better than what I just said.
No, I'm not. One thing I want to make clear to the board is the applicant, whatever the administrative code requires, will comply with. That's the only thing I can really add to that, so I appreciate that, Rich.
So with that, if I can bring Mr. Murphy to the stand. All right? Want to swear him?
I will.
I'm sorry.
The thing we just said. That's regulation, it doesn't permit all-inclusive or doesn't permit unlimited alcohol? What does it
It's
say?
specific to alcohol consumption, unlimited alcoholic consumption. So I can provide the actual statute or administrative code regulation to you if you want, but it specifies it's solely related to alcoholic beverage consumption on a licensed premise.
So you can have an all-inclusive resort, you just can't have unlimited alcohol.
That's correct. Absolutely. If you wanted to carve that out, I think it takes away from the nature of an all-inclusive, but you could. Yeah.
Okay. I just don't know you're ever allowed to have unlimited alcohol consumption. There's a bunch of rules that prohibit that. All right, go ahead.
Brian?
All right, hold on.
And this is just the fan is going, the record needs to be, if they want to come up here and use 2 separate microphones, I think that might be better than trying to just share that one. That would just be my 2 cents.
Well, that's fine. Thank you, sir. That's chairman stuff.
Is that all right?
Go ahead.
All right, thanks.
Mr. Murphy, do you swear or affirm to tell the truth, the whole truth, and nothing but true stuff you got?
Yes, I do.
Brian, given
I don't want to force the issue, but we had a time limit on on what we were talking about here. How much longer do you think you're going to be?
I think we're going to take a little bit of time, more than likely, right? Can you limit it to the professionals? So, I mean, I guess you can,
I would
but
not limit a paid professionals to 5 minutes. As long as it's not redundant, I would let him do his testimony.
that's fine. And I don't believe we're going to be,
He doesn't go on long. He kind of hits his bullet points. So
and we've got those
that's
outlined.
my experience.
So, Brian, quickly before you get into it, can you put your professional credentials on the record, please?
Yeah, I'm a professional engineer and a professional land planner.
Go ahead.
Thank you.
And it's in New Jersey. Thank you.
And Brian, can you confirm that while we didn't provide testimony, you were here at the meeting on April 8th and you heard the testimony provided by the applicant that evening?
Yes, I was.
All right. Now, after reviewing the application, listening to their testimony that evening, can you give the board your professional opinion, just overall opinion, on the proposed development at the Jetty Hotel site?
I believe that, in summary, it is too much for this site. I think someone said the restaurateur said it's 20 pounds in an 8-pound bag. What was unique.
Get your microphone closer to you, Brian.
Sure. But I believe that it is not in the best interest of the city of Cape May for 2 reasons. One is from a planning perspective, and the other one is from an engineering perspective. So going on the planning perspective first, as you stated that there are 5 reasons that or criteria. Thanks.
All right. You just got to get real close to these things. That makes me crazy. It's not.
Lost my train of thought.
5 criteria.
There's 5 criteria for the granting of the variance. And as we look at this, Mr. Amenhauser has stated that we have to show that it benefits the community in general. It is not a benefit to the applicant. And one of the ways we look at that, we look at special reasons. And we say, do these special reasons, are they a benefit to the community? If we look at them and we say, well, if we do not meet these special reasons, or it contradicts a special reason, then the corollary would be true that this should not be approved because it contradicts some of the special reasons of zoning. And we all know the special reasons, so I'll go by the
letter.
The letter, thank you. Starting with E, to promote an establishment of appropriate population densities and concentrations that will contribute to the well-being of persons, neighborhoods, and communities. And I believe it's been testified ad nauseum tonight that the concentration that's being proposed here this evening is not in the best interest of the neighborhood and its immediate community. I also believe G is to provide sufficient space in an appropriate location for a variety of agricultural, residential, recreational, commercial, and industrial uses, and open space to meet the demands of all New Jersey citizens. And I believe that there just isn't enough space on this particular site to do what's being proposed here this evening. I think H is a big one, which is to encourage the location and design of transportation routes which will promote the free flow of traffic while discouraging locations of such facilities and routes which will result in congestion or blight. And I'll testify later on about that, about the congestion that's associated with this. And the last one, I believe that it this application directly contradicts is J, which is to promote the conservation of historic sites and districts, open space, energy resources, valuable natural resources in the state, and to prevent urban sprawl and the degradation of the environment through improper use of land. And I believe what's being proposed here this evening is improper because of the density. Now, getting back to the free flow of traffic, what I've done is I've taken a photograph of page 2 of 5 of the site plan that was provided as part of this application prepared by Mr. Schaefer, as well as an aerial photograph from Google Earth. And we have copies for everybody.
I think he gave it to you.
Make it M1 for Murphy 1. So it's a packet with,
What it includes is the second page of the site plan utilized by the applicant and then the Google aerial shot.
Mr.
taken-
Chicanis, you have a copy of this, correct?
he does. Well, so I'll walk over and give it to
Yeah,
you.
I handed
Okay.
it.
Okay, very good.
So, Brian, do you want to go over
Sure.
that and the issues that you believe can be found?
Yes.
When viewing.
In written and red are my comments. So there was one gentleman here this evening, I don't recall his name precisely, who stated the easement and had a concern about the easement. And that's at the top of the page, and there's a landscaped area at the north end of this property. So it is a 25-foot wide easement. In this 20-foot wide easement is a 12-foot wide loading zone and a landscaped area that was not dimensioned, but I believe it's about 5 feet just by scale. So that leaves 8 feet for two-way access for the dwelling in the back. So if there's a truck parked there, loading, unloading, making deliveries, picking up the trash, that there is only going to be enough room for one-way traffic. So if an emergency vehicles have to get back there, whether it be a fire truck and a police car, once they're back there, there's not a way to get two-way traffic. Also, testified at the earlier hearing was that it was a solid wall on the north wall of the building. I did not hear any testimony this evening that contradicted that statement from last April. So I believe that it is still a solid wall on the north end of the building. There are 7 parking spaces that are stacked in there. What's odd is that those parking spaces do not line up with the parking spaces immediately behind them. That means you would have to move 2 cars before you could access the 1 car that's up against the wall. So we're playing a Chinese fire drill to get any of those 7 cars out. There are a number of crazy motions that would have to be made. But the one I want to focus on is I put a star on the one on the left-hand side, which would be the west side. If
And
you look-
that's on the lower section away from the easement area.
It
reference,
is.
Right?
The
Yeah.
lower section, there's a star on it, and there's a 2, which identifies there's 2 parking spaces right there. So, to gain access to that space, we have to come into the entrance, the two-way entrance, come down the 12-foot wide drive aisle, and then do a 180-degree turn in 2 feet. Physically impossible for any car to do that. Or they would pull straight up and back in. Okay, they may do that. Now, 2 cars that are shown stacked behind that vehicle. So now the parking is clear, is full, and I have that car that's in the starred parking space. I come down, I say to the manager, I want my car. The 2 cars that are parked behind me have to come out. Now, they have to back out because they can't turn around in that area. There's only 12 feet. They have to back out onto 2nd Avenue, and they have to stay away. So I need 2 valets to take those cars off the site, and they either have to park in the immediate neighborhood and come back to get my car, or they just ride around Cape May until my car is pulled out, driven to the exit or onto Second Avenue so I can come out and load my bags and drive away. And then the two cars that were stacked have to come back. All this takes place, possibly another car wants to go out. So now we're up to 5 or 6 valet cars being driven all around the city of Cape May, looking for a place to land so they can come back and move additional cars. If this was in the center of Cape May, that would be difficult enough, because as you worked away from the building, you would have concentric circles that would grow, and you would have additional parking spaces available. This site is unique, and you flip to the next page, is that there's no parking to the south. We have the beach. There's no parking to the west because you have the ocean. And there's limited parking to the north and to the east. It's Second Avenue. You heard, I think, every owner of a dwelling on Second Avenue here complaining about the potential parking problems, because where are the valets going to park the cars? As close as they can to this building. Where is it going to be? On Second Avenue. And you can see why these people are upset over this application. All this assumes that it's a closed resort. If we include just the regular parking spaces, it's less than half of the demand. 48% of the parking spaces are being provided versus the demand. If we include the stack paces, it shoots way up to 58%. So we still have over 40% deficiency in the cars that are required as per the ordinance. So I see special reasons to vote against this application, where it will be a significant detriment to the community should this be approved. I also want to say that I believe, in my professional opinion, that the parking arrangement that's shown on this application is unreasonable for this application.
Is that it, Brian?
That's it.
I'll leave it with that. Thank you for your time. Thank
A
you.
question?
I don't want to let him go so fast. Mr. Murphy, did you hear the question I asked Mr. Amenhauser about the business plan?
I did.
Okay, what would your answer to that be?
I think
Opinion as a planner.
my opinion as a planner, that that plan would have to be developed. That was a core pillar to their argument, was the use of this as a private development.
Of an all-inclusive nature,
An all-inclusive nature, that you would come here, park your car for the week, for the day, not enjoy any of the restaurants, not want to go out and sightsee the views of Cape May, go birding or whatever, but you would stay here at this location. And I am not familiar with it, so I can't testify that I agree or disagree that it will work, but as I listen to the testimony, there are more questions than answers that I heard.
I guess the reason that I'm struggling with it, and it's not just an academic curiosity, it's that a hotel is a permitted use.
Right.
Whether it's open to the public or not open to the public. It's a permitted use. And I guess I'm just struggling with, if someone comes in and an ice cream parlor is a permitted use, and the board says, nah, we don't want you to have an ice cream parlor, we don't think that's going to work there. That's really not what a planning board does. I've had to explain that to my parents a number of times when they're saying, they can't put a pizza, why they let them put a pizzeria there? We don't need another pizzeria. I go, well, that's not what a zoning board does. They don't make decisions about the success of a business. They do zoning and they apply standards. So I guess I do see the other side of it, and I'm going to ask the applicant the same question, but I want to make sure everybody has their best answer on the record in case one of my members relies on that as a reason, and I have to defend it on appeal. I want everybody to have their best answer. So
If I wasn't clear too, I just think the most commonsensical way to put it is when somebody goes to an all-inclusive resort, you don't intend to use a vehicle at all, if at all minimally, right? They're marketing this as such, as an all-inclusive resort, to Mr. Murphy's point, that you're going to stay at and otherwise not need to access the vehicle at all, if not regularly. That differs from a regular hotel where you're presumably going to be in and out of it multiple times during any given day to go here, there, and everywhere else, right? To eat, to go shopping, to go sightseeing. So
I'll just say the all-inclusive thing to me, the all-inclusive isn't what justifies the parking variance. not being open to the public is what they believe justifies the parking variance. So if this wasn't all-inclusive, but rather you had to pay for your pillow, as long as they don't let people from the public in, it has the same impact on parking. So that part of it is fuzzy to me. But the part that is interesting is the argument that, well, if their business model is it's not open to the public, and the board's not convinced that that is a business model that's going to succeed,
Right.
do they have to give you a variance under circumstances where they think that in 2 months or 2 years or 3 years, if that business plan isn't persuasive to them, that they're going to have a white elephant there that has a huge restaurant in it, and they're going to be left with the Hobson's choice of either saying it's got to sit empty till it rots, or we got to
Right.
let somebody operate in a manner that'll be profitable, like Congress Hall and the Cape May Inn and all of those things. So that's what the board, I can tell that's on some of their mind, and I'm trying to make sure my record's developed on that.
Right, and I'm just not sure that I completely agree. Even if this was a hotel not open to the public, but not considered all-inclusive, I still think the calculus changes. Because if it's a hotel that's not open to the public, you still have your guests come in that require the parking, but presumably at that point, they're going out multiple times a day. There's multiple cars leaving and going. All-inclusive, you're not expecting that to happen.
The unreasonableness of the parking is a legitimate opinion.
Right, I just think
And
it's the
your
crux of
engineer
this.
says that it'll work, and the board has discretion to decide if that works or not works. And if one of my board members grants it or denies it on that basis, I think they're totally justified
Right.
in their discretion to grant it or deny it on that basis alone. I listen to what the board says in their questions, and it's an interesting analysis that you're basing the justification for your variance on a particular business model. And I think once they do that, I think the board does get to judge that business model.
Right.
Just like a particularly suited use on a use variance. They try to decide if that use is particularly well suited for that location. So I do think they can do it, but I want to make sure your best answer's in there, Canis's best answer is in there, and then the board can decide on
Understood.
whatever basis they want.
If I can add then.
Everyone has had their chance.
If I can add just one thing to that, is that in my opinion, this parking arrangement, based on their testimony of being an all-inclusive hotel, it doesn't work under that circumstance. If you took away the criteria of the all-inclusive hotel, it makes it worse, not better.
I understand. There'd be more cars in and out because they're going to dinner instead of eating on the facility.
Correct.
I have a question to the engineer. Are you the engineer? Right. The plan you just showed us. The plan you just gave us and you discussed talked about that solid wall issue, and it also talked about the unevenness of the stacking parking spaces there. Can you tell by this plan or from your expertise that in addition to that being a stacking situation over there, those 3 parking spaces don't comply with the minimum parking dimension? I can't tell by this plan.
It's hard to tell. There's no dimensions available for me to calculate that. I would have to scale off the drawing, and drafting 101, you never scale off a drawing.
Yeah.
And, but I don't disagree with your assessment.
And the other question I had was that, did you notice that one of the spaces designated for EV compliance was actually one of the stacking and movable car spaces? In your perspective, would that be a smart thing to do, to have that parking space an EV space?
Yeah, I've never owned an EV. I understand it takes at times hours to charge up.
I don't know. I don't own one.
I don't know either, so I can't comment on that, honestly.
My question would be then, in your perspective, is placing the EV station in that spot, which is, they're suggesting it be a stacking situation, and the other EV station being placed in a handicap spot, which means that nobody who is not a handicapped licensed driver can use that EV station, does that diminish the effectiveness of the 2 EV stations within that building?
It does, and what they can remedy that by making another parking space or 2 a handicap and limiting them to exclusively handicap.
Or move the EV station.
Or move the EV
someplace.
station,
Okay.
correct.
All right. It just looks like those 2 spaces are being overused.
Correct. It's just, it's a complicated parking arrangement.
Thank you very much.
Very good, thank you. Mr. Candice, you wanted to rebut anything? Yes. Go ahead.
No, sorry. So, just preliminarily, I just want to let the board know, we are going to be presenting rebuttal testimony, first from our engineer and planner, Mr. Schaefer, who's going to go address some of the comments made by Mr. Murphy. Mr. Shropshire is going to do the same thing from the parking and traffic aspect of that. And then I'll likely have Mr. Marshall come up and clarify and challenge some of the things that were said as I don't know how to pronounce the gentleman's last name, but the slideshow that was presented referencing his website and some of the assertions that he made. So he's just going to clarify a couple of those. And then Mr. Demutis would like to come up as well to clarify and make certain things clear. So we're going to have quite a bit of rebuttal testimony, it looks like.
No, you're not. Traditionally, rebuttal testimony is limited in nature.
It's limited to what?
Yeah, it's limited. You don't reserve 3 hours for rebuttal. I don't know if you've ever been in the appellate division, but you reserve
have.
between 2 and 4 minutes. So whatever rebuttal they have needs to be concise and direct and not rehashing their testimony. So
It's not going to be rehashing of the testimony, but it is going to be addressing, well, it's because it's going to be addressing
we're
about,
voting tonight.
Let me go.
that's,
All right?
All right. So one of the first comments Mr. Murphy made was it's too much for the site. And there's an easy way to measure and control that, and that's by looking beyond the building envelope that's created by the building height, front yards, the yard setbacks and so forth, which we are not asking for any variances, as well as site coverage, which we actually have improved to make it compliant where it previously is not. Appropriate populations, one of the special reasons is there is no density requirement for hotel, or limit rather, for hotel in the city of Cape May. And again, we're not asking for any coverage variances, which would also be another measure of that shortcoming if there was a shortcoming. Open space, again, item J on the special reasons. We're not asking for any coverage variances for the permitted uses that we're asking for. Free flow of traffic. Now, there's one thing I think I really want to point out again that's an important part of this project. 2 of the frontages on 2nd and Beach right now have parked cars on it with their bumper usually hanging over the sidewalk area where pedestrians are, and then they're forced to back out onto either Beach or 2nd. That is completely being eliminated. And in fact, one of the benefits to the town is we are able to, assuming the city decides they want to follow up on it, because it's not our purview or the board's purview, is to provide on-street parking, potentially 16 plus or minus spaces, measuring the spaces that the city of Cape May has on the next block on Beach. In other words, the distance between meters. It's the potential. The easement is an improvement over what we are showing, what's there currently. Right now, the easement includes a trash dumpster. I think I measured less than 20 feet away from the house of the resident that testified earlier. That will be moved indoors to the building. That's a benefit. The loading zone, I don't know of any driveways that are required to be wide enough for two-way traffic for residents. And right now, that's the only thing that driveway would be used for, would be for access to the residents. The parking garage, admittedly,
All right, can you just repeat that? Are you
sure? The
just
easement.
to understand the loading zone, is that in the area where that driveway where he'd have to traverse through the loading zone to get to his house, or no?
Even with the loading zone being used, there's still enough room for a vehicle to pass.
Okay, that's what the
Otherwise, if it's not a credible application. As far as the parking garage itself goes, admittedly, the traffic flow is somewhat cumbersome inside. So the traffic consultant and I worked together on that, where we could have provided more stacked parking. But as Mr. Murphy testified, if we had done that, it would require cars pulling out into 2nd Avenue, maybe circling the block and coming back to make that valet parking work. But the valet parking, the way it's designed, does work because we didn't try to over-park with the stacked parking what we show on the plan. So in my professional opinion, there is enough room to maneuver all the cars in and out of there without ever having to pull out on the street to retrieve a car. That's really all of the rebuttal comments I have. Unless you have questions.
That's how you do it. That was good. Good rebuttal testimony, Mr. Schaefer. Can I ask you one question?
Certainly.
Or two, actually. The first one's a setup. The second one's the real
Thanks.
question. The first one is, Do you agree that you can build a conforming hotel with conforming parking on this site?
Conforming parking in the way we defined it, which means we provided self-limitations on the use of the property, the permitted uses, by not opening to the public. So now we're...
That's not what I'm asking. I'm saying, because the answer to this question is yes, because there was an application previously where they had a hotel with 33 units and no variances, to my recollection. So something like that. Isn't that true?
That's correct, yes.
Okay. So they could build a hotel with 33 units and no parking variances.
Of course.
Okay. Why is this hotel that you propose now a better zoning alternative to a compliant hotel that can be built on the site?
I think I'm not prepared to answer that as much as Mr. Demitis probably should. It's a business model.
That's the question, right?
Right. So this, what in my professional opinion, the degree of development fits without causing a detriment to the neighborhood. And again, because we're limiting the way who can use the property. In other words, key carded guests only. So if it were open to the public for restaurants, yes, it would be a traffic nightmare. Yes.
Okay. That's a fair answer. I mean, so you believe that this is a better zoning alternative to a compliant 33-unit with compliant parking hotel that's open to the public. This is a better zoning alternative to have more units, the parking variance of being closed to the public.
Yes, because the applicant truly believes that there's a better market for this kind of development in terms of visitors to the site as opposed to a conventional hotel.
And you believe that this, not open to the public, even with the parking variances, will have less of an impact on the neighborhood because it's closed to the public? That's your preference?
That's correct, yes.
Okay, fair enough. Thank you.
You asked my question, so.
Sorry.
You asked my question, so I
Well,
can
that's the
kind of
only
leave it at
question.
that.
Well,
That's
you get 5 hours, but that's the question.
understood. So, I think, hold up, excuse me one moment.
I think I'm being kicked out. What's that?
I think Mr. Shropshire is briefly going to supplement Mr. Schaefer's testimony relative to the parking layout.
Yeah, I concur with what Andy said with regard to the parking works because it's a valet system. Stack parking works because it's a valet system. The constraints that were talked about with regard to how you maneuver in and out of this, it works because it's valet. If this was a public parking area, it would have a lot of complications. It is not. So a key to this is that it's a valet system. Therefore, I believe the variance that's being requested for stack parking is a valid variance and can be supported. And I also believe the parking variance with regard to the number of parking spaces that are being required, again, it's not a density issue per se. It is exactly what Mr. King said. If the public's not allowed to use the restaurant, the pool, the library, if they're not allowed to use that, then you don't need the parking spaces associated with that. And I think that provides ample justification for the parking variance.
And in fact, the master plan of Cape May actually encourages systems such as satellite parking, valet parking, in an effort to pull cars off the street. Isn't that true?
Correct. That's all I had.
Okay. Next, we have Mr. Marshall, who's just going to come up and address some of the testimony relative to his company.
Hi there. First of all, I am not a partner in this adventure at all. In fact, I'm not even being compensated for my time here. I hope you get a cocktail afterwards from Mr. Demutis, but other than that, I'm just here as a hotel guy. I do not have any ownership of any high-rises in Ocean City, Maryland. So the gentleman that made that assumption is incorrect. I will admit that I do not, currently our company does not run any all-inclusive hotels. However, we have many inclusive services, inclusive packages. In fact, he showed some of them on the website that was on his slides. So the definition of inclusive has been evolving. So one of my testimonies earlier was that Hilton and Marriott and Hyatt are getting into this space because the definition of all-inclusive is no longer the same. We get to choose what's inclusive. We get to choose what's included in the package that we sell. In fact, I'm also a history major, and if you look at the history of Cape May and on the city's website, it shows that back in the early 1800s and 1900s, the boarding houses, the guest houses, were inclusive. So you stayed down here, you got fed. I think at the time they didn't have alcohol because a lot of them were operated by various religious groups. But this community had inclusive housing arrangements for many, many, many decades. So one of the other questions was we are unable to have as many or as few employees as was indicated. The fact of the matter is we're going to have fixed meals. We're going to have fixed menus, so you get to choose what you're going to eat. We also have fixed seating times. So I don't need as many employees because I've already know what I'm going to serve and when I'm going to serve it. And then as somebody else mentioned, there's never seen a library in an inclusive place. Well, that's nonsense. There's library, game room, whatever name you want to put on a room, it's a place to go to be quiet, to be out of other people's ways. So, anything else?
Any questions from the board? Seeing none. And finally,
Sid,
Mr.
quick.
Demunis would like the opportunity to speak in approximately 2 minutes, and then we should be good to go.
Thank you. I can make it quick. This project started in 2005. The question was asked, what about the 33-unit motel that required no variances? Well, that was ultimately rejected. There was one that was approved, but was approved with conditions. We started our first planning commission meeting here in 2005, and now we're here in 2025. Same plan, same little tweaks here, little tweaks there. We've done it every which way we can. To answer the question about the business acumen, I find that incredibly interesting, right? You make an assumption that the person who has invested all this time over the last 20 years doesn't have the business acumen to run a hotel in a business that his family's been in for 70 years. I find that fascinating. But nevertheless, we feel very capable that we can run this place. We feel very excited that we're here. And this project started in 2005. So when I was listening to the testimony from the people that got here in 2018, I thought, oh my God, your neighbors were my protesters. And the people they bought your house from was. So I think we've put together a plan that has a limited impact on the neighborhood and follows the zoning and creates a beautiful building. And that's all I have to say.
Okay. If, Rich, I realize we're coming up on 10 o'clock, which is usually the deadline. I would just like to make some closing remarks and address what I think is probably the most pivotal question. And Mr. King, I think you hit the nail on the head because that's really the ultimate question about this application, I think. So Mr. Hurlis went through his review letter in great detail and demonstrated that with the exception of 2 variances, one is related to the parking, the other the use of stack parking, this proposal is 100% compliant with the city's zoning ordinance, including setbacks, impervious coverage, again, which we're decreasing, bringing it from non-compliant to compliant with the inclusion of additional green space. So in terms of the site suitability, this is a permitted use on site. That's one of the things that I think is very interesting about this application. And it's been mentioned a couple of times, so I'll bring it up now. This site has been the subject of prior applications. One of which was it dates back to about 2010. For context, I was still in high school at the time, so it's been, and I had a heck of a lot more hair on my head, so it's been quite some time. But recently, when I've been involved in, there was an application in 2018 which was approved, and then the extension of that application was denied in 2022, I believe, approximately. There was another application, which is, I think, a bit more important for the context of tonight, which was in 2021, which proposed something similar in the context that a restaurant, which was going to be open to the public, which there was a tremendous amount of pushback on, despite the fact that the applicant proposed the use of satellite parking as a conditional of approval. So what's interesting about that is that the applicant took a lot of what the public said and what the board expressed concern about with those applications. And this is a separate applicant. That applicant was Cape Jetty LLC. Now it's Avu LLC. So it's a different applicant, but many of the same players. We took into account some of the board's and the public's concerns. The chief one was the use of public parking. That was the primary source of concern, and rightfully so, given some of the conditions that exist on Beach Avenue and Second Avenue in that area. So what the applicant proposed was to limit the amenity spaces to the hotel guests, something we've said ad nauseum. But then the message at the time was okay, and this was really hammered home by the board when we asked for our extension of the prior approval in 2019. That was also a completely conforming hotel with limitations on the amenities of the hotel guests, to the hotel guests. But the question in that application became, how do you enforce that? How can you really enforce that the amenities are limited to hotel guests? The applicant's answer to that question was the all-inclusive business model. And Rich, I think this gets back to your question of, can the board consider the business model in terms of granting the variance? Because there's a lot of case law that deals with the fact that when you're dealing with a permitted use, the business model itself is not a valid zoning consideration. But then it's been posited that we're presenting the all-inclusive as justification. And I think it's a bit of a fine-tuned distinction to be made. And I think the board solicitor touched on this, and I think he hit the nail on the head. The justification for the variance is not the fact that this hotel is going to be all-inclusive. It's the fact that the amenity spaces are going to be limited to hotel guests only. That's the large justification for the variance, and that, again, and that is actually better in terms of the use of the space as opposed to a fully conforming hotel that is open to the public. Because, again, accessory uses such as restaurants are fully permitted within the zone. So that is an option, in which case public parking would likely be necessary for those members open to the public. This restricts parking solely on site. There was a couple of members of the public who talked as if this was going to be made use of public parking, or we're going to need 60 spaces on the street, which is simply untrue. The all-inclusive aspect only comes into play as a means for the applicant and the developer to enforce the limitation on amenity spaces. That's how they're proposing to do it. The use of key fobs and all of the mechanisms there. And again, there's a number of cases that say that the use of the business model of a permitted use is not a valid zoning consideration. There are the only published case I was able to locate, and I'll just mention this for the board so it's of record, is Wawa Food Market versus Planning Board of Ship Bottom. That's located in 227 NJ Super 29. And what was interesting was that in dealing with that, the appellate division, this is a case from 1988, so it's a bit old, but it says they remanded the application relative to a C2 variance, which is what we're requesting here tonight. The court said, and quote, "In remanding, it is necessary we express our unsettling feeling that the denial of Wawa's site plan may have been predicated, at least in part, on the overall nature of the proposed use. In denying the application, the board expressed concern that, quote, this type of food market business will be detrimental to the public good, and that, quote, the existence of a business operating at 24 hours will affect adjoining property values. Individual members feared the store would become a teenage hangout and things of that nature. Such concerns must be remedied by an amendment to the zoning ordinance, changing the use of the property as opposed to a denial of a permitted site plan." That's verbatim from the appellate division, and there's two.
Was that a site plan approval, or was that a variance approval?
It was a site plan with C2 variance approval. So the same as here. And it was for a Wawa, which was a convenience store, which was a permitted use on site.
I can listen to it.
No, sure, that's fine. And then there's two more recent cases. They're unpublished, and of course they have, and Mr. Amenheiser, I'm sure, will hammer this if this goes up on appeal in either direction, but they're not of precedential value, but they can be instructive for the board's purposes. The first is Valentine v. Summers Point Planning Board, and this is from 2019, so much more recently. And it says verbatim towards the end of the opinion, whether a proposed business plan is economically feasible or consistent with the applicant's business model is not a valid zoning consideration. And there's another one, which is 7-Eleven Inc. versus the Planning Board of Elmwood Park, says a very similar thing. The business model is not a consideration. Now, again, it's been phrased that, well, it is because you brought it up as justification. That's not the justification. The limitation, the self-limitation of my applicant is the justification. The all-inclusive aspect of this this proposal, is simply the means of enforcement of that limitation. It's how we ensure that no members of the public do enter onto this site. I've said quite a bit about that issue, I think I've addressed what should be within the board's purview. Both Mr. Amenhauser and myself, despite the assertion here tonight that my applicant, my planner didn't address the positive negative criteria, he did. So that's of record and the April 8th application, and the record can stand on its own. The board is aware of the decision it needs to make tonight. I just wanted to make that very clear, that we're dealing with a permitted use that fits on site based on every available metric with the exception of the parking. And the other thing I forgot to mention, excuse me, that I'll mention very quickly, is that 135 number. 135 spaces, we're providing 79. That 135 number is calculated as if those amenities are open to the public. So for example, if the restaurant was open to the public, if the bar, all those places were open to the public, we would need 135 spaces. We're not open to the public, which again then brings it down to a much more manageable. We have enough parking spaces for the rooms. We have 57 proposed, while 56 are provided for the rooms in terms of the number of bedrooms. And then the stack parking has been discussed ad nauseum by the applicant's professionals. So we would respectfully suggest to the board that this is an application that does meet the positive and negative criteria relative to the C2 variance. It is a fully permitted use on site, and furthermore, the applicant has agreed to every proposed condition of approval that has been proposed by the board and its professionals. With the exception of a fully conforming application with 0 variances, there is quite literally nothing else the applicant could have done to assuage the board and the public's concerns relative to this application. And with that, we respectfully request that it be granted here tonight. Thank you very much.
All righty, Rich, you want to give any suggestions of how to start from here?
Can I ask a question? If this gets passed as presented, and then you go ahead and open up that restaurant, as many people are worried about, to the public, and you change your business plan, what penalties can we have in place for that?
If I can I just briefly address one thing? The applicant, and I'll say this very confidently, the applicant cannot do that without coming back before the board. I'm assuming one of the conditions of approval here tonight, if it were to be approved, is that the amenity spaces be limited to hotel guests, which means if at any point in the future, this applicant, another property owner, at any point says, we want to open to the public, they will absolutely, without question, have to come back before this board in order to obtain approval to do so. And if, and I say this both as an attorney who represents land developers and as someone who was a public defender for 2 years, I do a lot of zoning violations as well. To ignore a condition of approval with respect to whether any part of the resolution puts you in violation of the city zoning ordinance, which encompasses all of the potential violations that come across there. And because of other issues that I've dealt with in Cape May, I know quite extensively that one of those options is upwards of fines, upwards of $1,250 a day. So that's the number of penalties that we would be facing to act as a Trojan horse and flagrantly ignore a condition of approval and simply open it to the public because now it's been built is simply not feasible, nor is it recommended, nor is it even legally possible. I hope that answers your question.
Anybody else on the board have anything you want to say?
I have a comment.
Go ahead.
Following what the attorney said here,
Talking to Mike.
following what the attorney just said here, you did raise the notion of the business plan as the reason why this is going to be, this should be approved. But you're right, the business plan is not nearly as significant in my mind as the size and the contents of the building is. Because if your plan, if you opened this facility and you had maximum occupancy, that would be 112 guests. You've got a building that includes a 9,000 square foot restaurant, library, bar, whatever. In addition to that, you have a spa, and in addition to that, you have a pool upstairs and a deck top bar upstairs. And it seems as though there's too much there for 112 people. And so that raises the notion that maybe with this business plan, because it has been so poorly presented to us in terms of its viability in New Jersey and in general, and in Cape May in particular, it leads us to consider whether or not the building was just going to be a refit from an older building that may or may not fail as a all-inclusive resort, and then you will come back and you will ask us to let you make it a public facility because it's an overbuilt operation. It looks like the same restaurant, hotel, bar that you suggested 4 or 5 years ago, and the only difference is you're only letting 112 people in. And in the process, you're asking us to give you a variance of an ordinance that clearly does not permit this. Stack parking is only available by the action of the council to Victorian hotels who can't figure out how to do it otherwise. So the issue of whether or not this board is evaluating, in my mind anyway, evaluating the viability of an all-inclusive resort is not as significant as the issue of whether or not this building is what it's going to be and what happens to this city if it doesn't turn out to be that way. So that's a big concern I have, and I haven't heard any testimony from your side or anybody else's side that makes me comfortable with that appearance. So that's my comment.
Anybody else on the board want to say anything?
All right, I guess I should give you some kind of summary. I can't do more than this. I can't. Can you not hear me? Okay. No. I'm going to try to give you. I'm not trying to persuade how you vote. You know, I don't try to do that, and I don't vote. Okay, but I want to try to lay this out for you. A hotel in this location is a permitted use. It's near a residential zone, but that's how it is. It's a permitted use in the zone. So there's supposed to be a hotel here. The question is, what kind of hotel? And I've been dealing with this in many levels of the court for about 6 years now, maybe 7 years. And the primary objection of the neighborhood was that it was the open to the public problem. That if it's open to the public, it's going to be a madhouse down there. There's going to be a public restaurant and a bar, and people are going to come in from all over, and it's going to be a hot mess. So what the applicant does is they say, okay, how can we mitigate that problem? So what they do is they internalize it. They say, we're not going to be open to the public, which is a big sacrifice. All right, try to convince Congress Hall to not be open to the public. How much do you think they make from the public as opposed to their guests? All right, that's a major sacrifice by a hotel operator. And they're doing that in an effort to reduce the negative criteria, to reduce the impact on the neighborhood. That's what they've done. Now, in doing that, they've created a business model that involves this stacked parking and valet parking and, you know, a somewhat, I think someone used the complicated parking arrangement. And, you know, you need to weigh those benefits and the positive criteria, the negative criteria, and the, you know, whether the purpose of zoning are advanced. The purpose of zoning are advanced by this. I mean, if one of the purposes of zoning is to reduce the impact on the neighborhood by making it not open to the public, that advances a purpose of zoning. And it's a permitted use. So you're supposed to encourage the permitted uses in the zones where they're permitted. So that all is there. There's a basis to grant this application, but there's equally a basis to deny it. They presented a valet parking plan that you may or may not find persuasive because it's reliant upon a persuasive valet parking plan. They presented a parking lot that has a design that you've heard competing expert opinions as to whether or not that is an effective parking design, because that parking design isn't effective, and they can't maneuver all these cars with the number of employees they have, and the cars are backing up on the second street. That's not a good zoning alternative, okay? So you have a basis to deny it. Whether or not you think an all-inclusive plan will work in this town or not, I'm not saying you can't base your decision on that. Even council admitted the law's a little fuzzy. I gave everybody a chance to hit that on the head, and no one really did. It's not their fault. I just don't know that anyone has really analyzed this way, where the variance is based upon the success of a, they're going to build a hotel based on this business plan. If that business plan isn't persuasive to you, I'm not sure you have to give them a variance to build the hotel that they're proposing with this parking design. I don't know the answer to that legally, but I do know that if you don't find their valet parking plan credible and you don't find this parking lot to be a safe parking lot, that if you base your decision on finding their expert, the objector's expert, more credible than the applicant's expert, I think that is a solid area of your discretion and what you're supposed to do. If you think a hotel that complies with parking, that has less units, a smaller restaurant that has compliant parking can be built on this site, open to the public, and that's a better zoning alternative than this, then you have a basis to deny the plan. But be careful what you wish for, because it may be that this is the best plan for that area because it's not open to the public. So you may not get another chance to vote for something that isn't open to the public. Okay? So that's the weighing you're doing. That's your job. So you need to, consider that, weigh it, and vote. Articulate the reasons why you're doing what you're doing. They don't have to be the reasons I just said, but I need you to put your reasons on the record. If you don't like the parking, say you don't like the parking. If you don't trust the valet, say you don't trust the valet. If you have doubts about the business plan, then you can articulate that, but also articulate any other reasons you think are legitimate. And if you think that, although the public speakers don't seem to like it, that you think it's a better zoning alternative, that the applicant has listened to the prior problems and have tried to address it in a way that's a better zoning alternative, then vote in favor of it. And I think you'd have a basis to do that in the record. So I think you're supported in the record either way. I've given some of the reasons, give your own. I don't vote, but the motion I'd recommend being made, how you vote is up to you, but we always vote in the affirmative. We always propose it in the affirmative. So yes approves it, no denies it. The motion I'd recommend being made, but how you vote is up to you, is a motion to grant preliminary and final site plan approval with a C2 variance for the variances outlined number 1 and 2 in the engineer's report, which at present is parking with 57 single spaces and 22 stacked spaces for a total of 79, with a number of units set forth in the application, with a condition 1B on page 3, the waiver, which you've already approved, number V on page 4, waiver W on page 4, condition AA on page 4. There's another condition, bear with me a second. Comply with the loading and unloading between 9 a.m. and 5 p.m., and complying with the recommendations of the various entities that put an input on number 23 of page 10. That's the motion I'd recommend being made, but how you vote is up to you, and I ask you to articulate your reasons. Mr. Hurlis, okay? Covered your letter? Okay. That's the motion I recommend being made, but how you vote is up to you. And I incorporate by reference the analysis of Mr. Amenheiser on the elements of the variance. Not that Mr. Chicanis disagrees with it or said it wrong. I just mean that his 5 elements are the elements you're supposed to consider on a C2 variance. So I want to incorporate those by reference, so I did say the standard for the C2 variance.
Okay, somebody has to make the motion in the affirmative.
I'll make the motion.
Is there a second?
No one panic. You can vote no if you make the motion or you second it. So don't, that doesn't have anything to do with it.
I'll second.
Thank you, Mayor. I didn't want to do it again.
Are we ready to call the vote? Okay. We have a motion by Deputy Mayor McDade, seconded by Mayor Mullick. Mr. Gorgone.
This is a tough one. First of all, I do appreciate the public coming out, the effort and the time that you've spent, and apparently some money that you spent too, for attorneys and engineers.
I'm terribly sorry to interrupt. I'm just going to ask. the fans are going. This is important for the record, I think.
Yeah, speak loudly into the microphone.
I think it's helpful if you just basically just hold it and speak into it as if it's a microphone. It kind of, thank you.
Sure thing. As I was saying, I do appreciate the input from the public, the time and the effort that they've put into this. I do have a number of comments on this before I let you know what my vote is. As the planning board, we do have a certain responsibility, and it includes master plan development and reexamination, site plan review, to ensure compliance with land use development regulations, and review of variances, which allows deviations from the zoning regulations, and in this case, parking. And I think parking is the issue. We've listened to a lot of testimony. We've reviewed a good stack of documents here more than once. We've listened to the public. Why do people come to Cape May? They come here for a number of reasons. First of all, Cape May is a resort. It's a beach destination. There's a variety of things for people to do here. There's various price points that people can choose. I mean, they can choose Congress Hall, or they can choose the Clinton Hotel. They can choose Primal or the Seaview for a restaurant, all kinds of different price points. So to me, taking into consideration the price point that's being proposed here and the use that's being proposed, people probably would choose that type of an option. I believe that there is a need for hotel rooms here in Cape May, more hotel rooms, to be honest with you, because that's the livelihood of Cape May. That's what brings revenue into the city of Cape May, to the city's coffers in the form of use and occupancy taxes, brings revenue, beach revenue here to help maintain the beaches, pay for the lifeguards, and so on and so forth. Trash is not an issue because the owners pay for trash here. The city does not pay for trash. The hotels contribute millions of dollars to the city of Cape May. So the more people pay for a hotel or motel, the more money that the city is going to get in use and occupancy taxes. The business plan has been provided. To be honest with you, I don't have the expertise on that side. I'm an engineer. I'm not one that deals with hotels, other than I like staying in hotels. I have stayed in all-inclusives. I've been in hotels that provide breakfast only, both in this country. I just came back from Europe, as a matter of fact, and it's something that's easy to control. All they do is they ask you for your room number and your name, and you're allowed in there, and you get your free breakfast. And the same thing with the all-inclusives. So I'm not sure I can judge on whether the business plan is viable or it's not viable, but it's something that that they have presented. We've heard experts talk about it. Whether you agree with it or not, that's up to the individual. The building itself, the structure, forget about the number of rooms for a minute, forgetting about the parking for a second and the restaurants and so forth. That building could be built by right on that property. That size can go there, no matter what's on the inside of it and no matter what the parking is, as long as it meets the uses that that particular zone allows. And that includes the height and the footprint. So that could be built by right if it had the right number of rooms and it met the parking criteria. I'll be honest with you, I do wish that the restaurant and those combined spaces were smaller. I think it's way oversized. Cut it in half and put a pickleball court inside it or something like that, give the people something else to do. There are other hotels here that have amenities that are exclusive only to the people that stay there. They're not all inclusive, but Congress Hall has amenities. They have a pool. They have, as a matter of fact, they get, from what I understand, they get preferred reservations at the Brown Room and in the restaurant. I used to go to the Brown Room, but I can't get a reservation there anymore, so I don't go there anymore. But so it's kind of, all amenities are included for those who stay there. And it's a pretty healthy price point there, too. But I do wish that the that restaurant and the area were smaller than it is right now. Parking is an issue at the Cove. Okay, we've eliminated one motel already on Beach, and parking is an issue at the Cove. If this hotel were to be demolished and nothing were to go up there, parking would still be a problem at the Cove, as far as I'm concerned. During the summer, I don't drive to the Cove. I ride my bike maybe, or I'll take the jitney if I have to get down to that area. So the people that live here or come here on a regular basis, they know how to get around town in the summer. So to be honest with you, I'm less concerned about the spill out of possible parking issues there. I believe that this is an innovative project. I really do. And I believe it can succeed here. And based on that, I'm voting yes.
Mayor Mullick?
I think this should be a beautiful, nice hotel, and it should be. And I think the ownership has a track record that's wonderful in the city of Cape May. So you have what I think would be a really good start to a good project. And frankly, I'd like to get to a yes on this project because, again, I think the family, if you look at the other projects that they've done in town, they're beautiful. However, I think based on this application as it stands, it just doesn't meet the requirements for a variance, and I vote no.
Sorry, Deputy Mayor McDade?
Yes, thank you. Again, just a few comments. Appreciate the professionals and all of the residents coming out here and sitting through very long nights of testimony, compelling information on both sides of the table. I've gone back and forth on the business model and have basically taken it out of my equation. I'm not going to question the business acumen of the applicant, but I am going to consider the impact of this property and it being built in that area and the impact of the flow. I don't agree with the parking plan as it was presented. It does create some concerns with regard to the impact to the public in the neighborhood. The density of this project mentioned some things about the engineering, the flow, and so for that reason, I will be voting no.
Mrs. Reed?
I'm going to concur with Deputy Mayor, and I appreciate all the comments from everybody out there. They were heartfelt, and I heard them. And some of them we can't base our vote on, but I also think that that parking, with the trucks doing deliveries in that easement, I just can't go along with this plan. I vote no.
Mr. Crowley?
I'm basing my vote on 4 points. The first of which is that, as I just articulated a minute ago, I think that the design of this building is not nearly as conducive to what they want to do as it should be. If you take all of the amenities in this building, and I did a little math up here. If you take all the amenities in this building, that dedicates 125 square feet to every single person that goes into this building as a guest. It's just too much. And so the design is something that troubles me. The parking situation troubles me even more. And I'm pretty clear that the city council, whenever they pass the ordinance allowing stacked parking for Victorian hotels only, we're never intending stacked parking to be used as a viable integral element of a brand new building constructed anywhere in the city. Stacked parking flies directly in the face of everything else the code says about having off-street parking. it is something that would create a significantly bad precedent for everything going forward in this town as it's developing its commercial identity. And so for that second reason, I would vote against it. My third reason is that such a concept really doesn't contribute all that much to the viability, the vibrancy, the integrity of Cape May as a community resort. Since the applicant raised the notion of an all-inclusive resort, I think back to a couple months ago when I was in Cancun. I stayed at an all-inclusive resort, and there's a lot of them down there because if they didn't have them, nobody would go to Cancun for any reason. People come to Cape May for a lot of different reasons, and suggesting that they're all going to be encloistered in this little location down on the cove and get their own meals, have their own entertainment, and to the point of what goes on in the library, their plans show that there's a piano in the library, so it's not going to be a quiet reading place. It just doesn't fit with what Cape May thinks it is. It doesn't do much for the 25, 30, 40 restaurants in town, not that it has to, but it just seems to me as though it's a concept that's untested in New Jersey, untested in Cape May, and for us to be the alpha test of this concept in a building like this is going to cause us problems down the road. So I would vote definitely no. My vote is no. I can't see it.
Mr. Lundholm?
Excuse me. I agree with the deputy mayor. I don't agree with this parking plan. I think shuffling those vehicles around in a tight spot is going to require a lot of in and out onto the street, back and forth, and for that reason, I'm a no vote.
Mr. Riggs?
Thank you. Obviously, we heard a lot of testimony going over 2 nights. Obviously, I asked some pointed questions about different things within the plans. I have to agree with the mayor. You know, I would like to get to a point where, you know, there could be something done down there. But, however, going through the testimony, I don't think at least the questions that I asked were sufficiently answered as they relate to the parking situation down there. So I'll be voting no.
Mr. Paducas?
Thank you. I want to thank the board first for their in-depth consideration of this application and their remarks. I want to thank both councils for being here tonight, the applicant and the citizens of Cape May. You have to prove hardship, and hardship wasn't proven to me tonight. In the last meeting that we had, I don't know if it was me or someone else asked the question to the applicant, would you be profitable if you just replaced the restaurant with the same amount of rooms? And he said yes. So it would be profitable. I don't think that this town's ready for an experiment. And if this issue went to referendum to vote in this town, it would definitely be a no by a large majority. I just don't think that this concept would work, but I'm not voting no because of that. I'm voting no because of the parking. This would set a precedent for other applicants to approach us with other hotel concepts, restaurant concepts, and we just can't do that as a board. So I am voting no.
Mr. Jones?
Being last to vote, I suppose I'm voting yes on this application. Every one of you property owners there has legal rights. Every one of you. This guy has a legal right to put a motel here. And I think most of the people in this audience don't want that motel there, period, no matter what it is. I don't, listen, that's my opinion, people. That's my opinion. That's my opinion. We can't lose any more motel rooms. We lost the Mount Vernon. We lost the transient operation from that. This is I'm not basing my opinion on the fact that of this all-inclusive idea. I mean, I'm not convinced that it's going to work. I'm not convinced that it wouldn't work. But the fact that the applicant proposes the all-inclusive minimizes the parking issues down there. And I don't know what else to tell you about the viability of this project, other than the fact that, I don't know, we just can't lose any more motel rooms. And I still would vote yes on this. Thank you.
Okay, I have, No, he doesn't vote. Chairman goes last. So, I have a vote of 7-2 against. Thank you, council. You guys did a good job. Sorry. Thank you.
Do we have a motion to adjourn?
What's that?
Do we have a, are you?
Can we have a motion to adjourn, please?
Yes, I'll make the motion.
I'll second.
I'll second.
Aye.
All in favor? Aye. All right, thank you, everyone.
No, I'm going to Ocean City. I'm not going.
I think I have it.
All right, so what are we addressing, Craig?
We are,
Testing, testing.
A draft ordinance regarding proposed clarifications of exemptions from site plan review were forwarded to us, and I was asked to do a consistency review for that proposed ordinance. That's part of your package. That essentially clarifies the exemptions from site plan review. It's precipitated from a recent application regarding a quad, whether there should be the necessity of having a site plan review required for it. I believe the governing body is considering the changes with regards to that. And the changes are essentially saying that notwithstanding the above, any application for development of a quad that requires variance relief shall be subject to site plan review incurred by the planning board unless the variance is implicated by the application, in which case the zoning board will hear the application. So quads have been exempted unless there's variance approval required, in which case site plan approval will be required by the appropriate board that has jurisdiction.
So that mitigates the issue we have.
yes, yes,
so,
sir.
so if they're conforming,
Yeah.
they don't need site plan, they can go pull a permit. That's what the proposed ordinance says. As part of our review, we have to review potential land use ordinances. There is language directly in our master plan reexamination that refers to reexamining and considering changes to the R4 district. I believe this falls right in that window, and therefore I believe it is consistent with the master plan, and you're allowed to make that recommendation to the governing body, as well as you can also recommend additional changes.
I move it. I think it fixes the problem.
Right, yep, yes. Agree, yep.
There is another one. The next one was review the standards for exterior air conditioning units in the R4 district. It's very similar. What we had, it was a case where someone put an air conditioner above the roof line in the R4 district, in the Village Green. Not something that the ordinance contemplated. The ordinance specifically has controls for air conditioning units in the Village Green. However, that was not one of them. So didn't make sense to me. That's the proposed change. Once again, the R4 language in the master plan recommends review of that, and therefore I believe that you can find it consistent with the master plan and recommend that to the governing body for approval.
I agree.
I agree as well.
Yep.
And then finally, there was a draft ordinance amending Chapter 194 of the City Code to require notification of work to adjoining owners sharing a party wall. So if you're a side-by-side duplex or a quad and you're proposing work, this is a be good neighbor.
It's a good neighbor policy.
Good neighbor policy
Yeah.
in which you're going to notify them and letting them know. It's not the normal noticing requirement if you have a variance. It's just saying, I'm pulling a construction permit
just be advised.
It's a courtesy, especially because there's a blend in that area and all over the city of people who are residents and next door might be a seasonal person. So, yeah.
why we're voting on it. Yeah, you don't
Have to.
And I didn't do a consistency review. It's not a change to the zoning code. So therefore, it's just.
I don't think we should touch that one. I think we should.
Yeah, I'm just letting you know that that's what's proposed.
Can I just make just a quick question or comment on that one before we move forward on it? So just quick question on it. So condominiums, is there a mechanism to notify people within a condominium association already? You know, so if I'm doing work in a condo, is that, 'cause I'm just trying to make sure that everything is
I don't think so.
consistent.
Form of ownership. This is just if you have a party wall common to other people in that same structure.
Right, okay.
And what he's saying.
It could be a condominium.
Condos, do they notify everybody that they're doing a project?
Them have management companies and their, HOA kind of guides some of the things that they're able to do with regard to construction and times and things of that nature. We just have to ask Chris about that one. And since the board isn't considering it, that we can just do that.
Yeah,
Yeah.
and I'm in full support of it. I just wanted, since the mayor and deputy mayor were here, we
Yeah.
should probably consider that, that's all.
So that's all I have.
Well, should we make a motion to approve the first two ordinances? As
Yes.
consistent with the master plan?
Make that motion.
Is there a second?
Second it.
Okay, Mr. Jones, did you motion? Who motioned?
Justin.
Me.
Mr. Riggs? Okay. And Mrs. Reed seconded? Okay, thank you. Okay, Mr. Riggs
Motion to adjourn.
motioned, Mrs. Reed seconded. Mr. Gorgon?
Yes.
Mayor Mullick?
Yes.
Deputy Mayor McDade?
Yes.
Mrs. Reed?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
I just have a question. As a quad owner, do I have to abstain?
No.
Yes.
Okay. Mr. Riggs?
Yes.
Mr. Produces? Mr. Jones?
Yes.
Thank you. And if that's everything, do we have another motion to adjourn?
Make that
to
motion.
adjourn.
Same one.
All in favor? Aye. Thank you, everyone. Oh, you're welcome.